Tonight's now in session. Honorable Judge Sarah B. Wallace presiding.
Good morning. Everyone may be seated. Do we need to talk about any preliminary matters, or can we get to the next witness?
I think we can get to the next witness, Your Honor.
Nothing from us, Your Honor.
Your Honor, I would just like to renew our motion to exclude the testimony of Mr. Magliocca.
I'm sorry, can you repeat that?
I would like to renew our motion to exclude the testimony of Mr. Magliocca under 702.
And that motion is denied on the basis of my previous written ruling. Anything from the Secretary?
No preliminary matters from the Secretary, Your Honor.
Great. Let's call our next witness.
Your Honor, would you like entries of appearance first?
Yes, thank you.
For petitioners Jason Murray, Eric Olson, and Sean Grimsley, Martha Tierney, Mario Nicholas, and Nikhil Suss.
Thank you.
Your Honor, on behalf of President Trump, who is speaking to you today, myself, Scott Gessler, Jake Roth, and Jonathan Shaw, and just how
Jane Raskin, Mike Melito, Nathan Volker, and Robert Kitzmiller on behalf of the Republican State Central Committee.
And good morning, Your Honor. Michael Kotlarczyk on behalf of the Secretary of State, joined with Jennifer Sullivan from the Attorney General's Office and Deputy Secretary of State Christopher Beale.
Great, thank you. And thank you, Mr. Wright.
Of course. Petitioners call Professor Gerard Magliocca to the stand.
Professor Magliocca. You raise your right hand. Do you swear under the penalty of perjury to tell the truth, the whole truth, and nothing but the truth in today's court?
I do.
Good morning, Professor. Could you introduce yourself, please?
Yes, I'm Gerard Magliocca,
How do you spell your last name?
Magliocca.
Where do you work?
I teach at the Indiana University Robert H. McKinney School of Law.
Now, you're here as an expert today. What topics are you here to testify about?
I'm here to give expert testimony on the history of Section 3 of the 14th Amendment.
How long have you been at Indiana University McKinney School of Law?
22 years.
And in those 22 years, has your scholarship had any particular focus?
Yes, I focus mainly on constitutional history.
Are you a member of any professional organizations related to constitutional history?
Yes, I'm a member of the Supreme Court Historical Society, the American Society of Legal Historians, and I'm on the board of editors of the Journal of American Constitutional History.
Can you give us a general overview of what kinds of published works you have in the area of constitutional history?
Well, I've written 5 books and something in the neighborhood of 20 law review articles on various constitutional history subjects.
Have you written any books specifically about the 14th Amendment or its history?
Yes, about 10 years ago, I wrote a biography of Congressman John Bingham, who was the main drafter of Section 1 of the 14th Amendment as a member of the Joint Committee on Reconstruction.
Have you written any academic articles or journals related to the history of the 14th Amendment?
Yes, I have 4 articles that cover just different aspects of the history of Section 1, Section 2, and Section 3 of the amendment.
Do you have any other articles about 19th century history?
Well, yes, several. I mean, some of them cover the period of Jacksonian democracy, some cover the period of the late 19th century, sort of around the populist period or the Gilded Age, and others of my books also focus on different aspects of those subjects.
You mentioned that you've written on the subject of Section 3 of the 14th Amendment. Tell us about that.
Yes, so in 2020, I drafted a paper on Section 3, and that paper was posted to the Social Science Research Network, which is the place where professors post their draft papers to share with the public, in December of 2020.
Was that later published?
Yes, that was published in 2021 in the Constitutional Commentary, which is a peer-reviewed journal run out of the University of Minnesota.
Before you posted your article about Section 3 on SSRN in December of 2020, give us a sense of the state of the existing scholarship on Section 3 of the 14th Amendment.
There really wasn't any.
How, if at all, has that changed since then?
Well, it's changed quite a bit, especially in the last few months.
Have you written any other articles about Section 3?
Yes, I have a draft paper that is going to be coming out in the Journal of Constitutional History, that's Constitutional Law, that is run out of the University of Pennsylvania. That was given as a talk at a symposium in January on the 14th Amendment.
Can you tell us whether any of your work on Section 3 has ever been cited by courts?
Yes, my original article was cited by the United States Court of Appeals for the Fourth Circuit, as well as a federal district court in Georgia.
Has your work on Section 3 ever been cited by any government agencies?
Yes, the Congressional Research Service cited the article in an analysis of Section 3 that they did.
Have you ever given expert testimony on Section 3 of the 14th Amendment?
Yes, I have. I gave expert testimony on the history of the amendment in an administrative proceeding in Georgia that was addressing the eligibility of Representative Taylor Greene.
I want to pull up Petitioner's Exhibit 162. What is this?
This is my CV.
Is it current?
Yes.
I don't want to talk about every entry here, but just briefly, can you summarize your educational background for us?
Yes, I received my undergraduate degree from Stanford and my law degree from Yale.
If we go to the second page, just tell us briefly which of the books on your CV relate to 19th century history or constitutional history.
All 5 are the ones that have been published.
And is this entry here the biography you were referring to about John Bingham?
Yes, it is.
If we go down to book chapters, law review articles, and essays, we see a few entries related to Section 3 of the 14th Amendment. Were those the forthcoming article and the previously published article that you mentioned earlier?
Yes.
And briefly on page 4, can you just highlight for us on this page of your CV some of the articles here that relate to 19th century history or the history of the 14th Amendment?
Sure. The one at the top is about Section 2 of the 14th Amendment. Then also the one, let's see, going down a little bit. Okay, why did the incorporation of the Bill of Rights fail in the late 19th century? There's a 19th century historical piece. And then also the one that's entitled Indians and Invaders, Citizenship Clause and Illegal Aliens focuses on Section 1 of the amendment, on the Citizenship Clause of Section 1. And the paper on legal tender cases, New Approach to Congressional Power, visiting legal tender cases, is about Supreme Court decisions on the constitutionality of paper money that were rendered in the 1860s and until the 1880s. Constitutional false positives and the populist amendment was about constitutional development in the late 19th century, basically focusing on the 1890s. Cherokee removal in the 14th Amendment was talking about the Trail of Tears and then how that had an influence on some of the thinking behind Section 1 of the 14th Amendment.
If we go to the next page of your CV, you have a list of recent professional activities. Do any of those relate to the history of the 14th Amendment?
Yes, so the podcast on Section 4, which I haven't written a whole article about that, but I did write about that in one piece of one article. I did a podcast with Eric Foner, who is basically America's leading historian on Reconstruction, earlier this year. And then the symposium piece is the one I mentioned earlier. That's my draft paper about another aspect of Section 3. And then there was a presentation about the Section 3 article last fall. And then I gave a talk last year about my biography of Bushrod Washington at John Marshall's house, which was kind of fun.
And on the last page, I'm not going to highlight all of these, but did some of these also relate to Section 3 of the 14th Amendment?
Yes, I did a podcast with Professor Dan Hemmel in January of 2021 about Section 3. That was, of course, in the immediate aftermath of January 6th, 2021.
And what about this entry about John Bingham with Kurt Lash?
Yes, so that was a podcast I did with Professor Lash for the National Constitution Center about John Bingham's career, and that was part of a series of events that commemorated the 150th anniversary of the ratification of the 14th Amendment in 2018.
When you're doing your historical scholarship on the 14th Amendment, what kinds of sources do you consider?
Well, I mean, I'm trying to look at primary sources because that's the best way to try to get at the truth of what happened. So I'm always most interested in looking at those.
What are the types of primary sources that you would look at in your scholarship?
Well, they kind of run the gamut, but you could look at congressional debates and reports, you can look at presidential documents, you can look at judicial cases, you can look at contemporary newspapers, contemporary books, basically any kind of source that would be a sort of first-hand account of what occurred in a particular time.
I'm pulling up Petitioner's Exhibit 144. What is this exhibit?
This is an index of the materials that I considered for my expert report.
And if we walk through this index, we see some cases, there's some citations to law review articles, some statutes, citations to congressional record, etc. Are those the sorts of materials that you would review in your historical scholarship outside the courtroom?
Yes, they are.
Tell us a bit about the historical methodology that you used in forming your opinions in this case.
Well, the first thing you want to do is make sure that the sources you're looking at are true and accurate. I mean, usually that's pretty straightforward because they are official government records of one sort or another. For example, there was an official compilation of presidential documents assembled at the end of the 19th century, and I have a set in my office that I found in a teach shop one time. And so I refer to that just to make sure that if I see a document online, that I can look it up to make sure that it's a real document and not some error in transcription or something. For newspapers, it's a little more challenging. I mean, there are some sort of trustworthy databases of old newspapers, ones run by the Library of Congress. You can also cross-check newspapers because typically an article would be reprinted more than once, or at least the sort of substance of the article would be reprinted in another newspaper, so you can try to make sure that whatever you're looking at is, in fact, an accurate rendition of whatever the article is discussing.
As a historian, what do you do if there's some kind of ambiguity or mismatch among different historical sources?
Well, look, the first thing you're looking at is kind of what is the context of the source you're looking at. Now, for example, in the case of the 14th Amendment, you would be more interested in what supporters of the amendment had to say than you would be about what an opponent of the amendment would say. In the same way that if you were looking at a judicial opinion, you'd be more interested in what the court said rather than what any dissenting opinions said to understand what the opinion was about. Also, you would look at who the speaker or author was. Now, some people were just more authoritative than others in their exposition of the 14th Amendment. And at the top of the list, or near the top, would be John Bingham, and not just because I wrote a book about him, but because he was centrally involved in all elements of the 14th Amendment's proposal and ratification and implementation. And this has been recognized by the Supreme Court many times and by scholars many times.
Can you tell us whether or not the historical methodology that you've just laid out was the method that you used in forming and presenting your opinions in this case?
It was.
At this time, petitioners move to admit Professor Magliocca as an expert in the history of Section 3 of the 14th Amendment.
Your Honor, we have no objection to Professor Magliocca's expertise. Obviously, we really would endorse the 702 motion there.
Professor Magliocca will be admitted as an expert in the history of Section 3 of the 14th Amendment.
Thank you, Your Honor. Let's start by setting the stage for the adoption of Section 3. What does the historical record tell us about why Section 3 was put into the 14th Amendment in the first place?
Well, the main thing that prompted Section 3 was that they wanted to keep officials who had left to join the Confederacy from returning to office unless they showed that they deserved a second chance to return to office. So basically, there were elections held throughout the South in 1865, after the war ended, and many of the same people who had been in office before the war and had left to join the Confederacy were returned to office, and some of them showed up to the new Congress and essentially said, okay, we're here to take our seats now, as if nothing had happened. And congressional Republicans were very upset at this idea. They felt that this was wrong. And so there was a proposal by the Joint Committee on Reconstruction to do something to exclude people like that from positions of authority unless they demonstrated some repentance or deserved forgiveness.
Does the historical record tell us anything about whether that was intended as punishment for insurrectionists?
Yes, I mean, it was not intended as punishment. There was a number of senators discussed the fact that this was simply adding another qualification to office because of the events that had occurred.
What does the historical record tell us about the role that the oath plays in Section 3?
So the oath plays a central role, not just in the text, but in the rationale for Section 3, in two respects. I mean, first is, it was a way of limiting the scope of the provision. They didn't want to disqualify all former Confederates from office or from serving. They wanted to focus that on the people they felt were most responsible for secession and the Civil War. And the oath was a way to do that. Now, secondly, senators said, if you had sworn an oath to support the Constitution, and you had broken it by engaging in insurrection and joining the Confederacy, it was a kind of moral perjury, that was a term that some people used, that you had engaged in, and you were just untrustworthy to hold office again unless you demonstrated some reason why you should be allowed a second chance.
What, if anything, does the historical record tell us about whether Section 3 was limited to the events of the Civil War or not?
It was not limited to the events of the Civil War, and we know that because first, the language was general, which is referred to insurrection or rebellion, and secondly, there were senators in the debate that made pointedly clear that they thought it also should apply to any future insurrection that might occur.
When did the 14th Amendment get ratified?
1868.
In the years after its ratification, walk us through some of the ways that Section 3 got enforced to exclude from office those who had been engaged in insurrection or rebellion in violation of their oath.
Okay, so this happened in different forms. In some states that were under martial law, the Union Army did the enforcing. In southern states that were no longer under martial law, state officials and state courts did the enforcing. Individual houses of Congress also sometimes did the enforcing if someone was a member-elect and then there was a question raised about whether they could be seated because of some involvement with the Confederacy. And then the individual House of Congress, the House of the Senate, would have to decide if the person could be seated or not. And then finally, in 1870, Congress created a federal civil action to enforce Section 3 by allowing U.S. attorneys to bring a writ of quo warranto to oust officials who were in office illegally because of Section 3.
You mentioned state courts enforcing Section 3. Tell us a little bit more about that history.
Yeah, so in 1869, there were cases in North Carolina and Louisiana that addressed enforcement of Section 3 of the 14th Amendment against state officials pursuant to state enforcement mechanisms. So in North Carolina, there were two officials who were removed from office as ineligible, and in Louisiana, they didn't remove the person because of a procedural reason, but they said that it could have been had the procedural posture been correct.
Were those cases in North Carolina and Louisiana before or after the enactment of federal implementing legislation in 1870?
They were before, they were in 1869.
Tell us a bit about the history of amnesty under Section 3 and Congress's power to remove the disability by a two-thirds vote.
Right, so as soon as the 14th Amendment was ratified, applications poured in from people who were disqualified seeking a waiver. Basically, you would apply to your member of Congress, and then what Congress did initially was pass a series of measures that would simply give amnesty to people by name. Right? There would be a list of names, all of these people get amnesty if you could get a two-thirds vote of each house to pass the legislation. After a couple of years, Congress decided to create a more general amnesty that did not involve individual names, and that was enacted in 1872 and gave amnesty to nearly all of the people covered by Section 3, except for a few hundred who were sort of considered the worst of the worst, including Jefferson Davis, the former president of the Confederacy.
And what does that history of amnesty tell you about the historical understanding of whether congressional legislation was needed to enforce the disability of Section 3?
Well, it tells me that people didn't think it was needed. Now, that goes along two dimensions. First, the people who were applying for amnesty must have thought that they needed it right away. And why did they think that? Probably because the amendment had been ratified and states were in a position to enforce the amendment if needed. Secondly, Congress granted amnesty to these individuals, in some cases, before any enforcement legislation was enacted. And in a sense, they were removing the disability that existed because the 14th Amendment had been ratified. They couldn't remove something that didn't exist.
I'm going to pull up the language of Section 3, and I want to first highlight the phrase insurrection. Have you studied the historical meaning that the word insurrection would have had at the time of ratification of the 14th Amendment?
Yes, I have.
What did insurrection mean at that time?
Well, according to the historical sources, an insurrection was any public use of force or a threat of force by a group of people to hinder or prevent the execution of the law.
What were some of the historical sources that you looked at that informed your understanding of insurrection as a public use of force or threat of force to prevent execution of the law?
Well, I looked at historical examples of insurrections that occurred before the Civil War, as informed by some presidential documents about them. I looked at dictionaries, I looked at judicial decisions, and I looked at an authoritative treatment of the law of war that was issued during the Civil War.
You mentioned historical examples. Tell us a little bit more about what historical examples informed the understanding of insurrection during Reconstruction.
Sure. Well, there were two notable insurrections early on in American history. One was the Whiskey Insurrection, which is also known as the Whiskey Rebellion, and that happened in 1794 in Pennsylvania. It was a tax protest by farmers who were angry at a new federal tax on distilleries that had been put in as part of Alexander Hamilton's financial scheme for the federal government. And during that time, armed farmers basically attacked federal tax collectors who tried to collect the tax, or used intimidation to prevent them from doing so. Eventually, President Washington called out the militia to sort of restore the legal authority of the government on tax collection, and a few people were prosecuted, but President Washington pardoned them all.
How many, roughly, armed farmers were involved in the Whiskey Insurrection?
In the hundreds.
You mentioned that there was another example you looked at. Tell us about that.
Yes, the second example was called Fry's Insurrection. That was in 1799. That was in a different part of Pennsylvania. There was a different group of farmers who were upset about a different tax. This time it was a federal property tax. And they used intimidation to prevent the tax assessors from the federal government from coming in and do the property assessments that would have been necessary to collect the tax.
And what was the scale of the violence involved in Fry's insurrection?
Well, there was no actual violence. There's no record of anybody being killed. And again, you're talking about hundreds of armed farmers who were sort of behind the sort of resistance to this tax.
If there was no actual violence, in what sense was it understood to be an insurrection?
Well, it involved a threat of violence. That is, there was violent intimidation of the federal tax officials. And that did the trick, at least from the point of view of the farmers, for some period of time.
What relevance did the Whiskey Insurrection and Fry's Insurrection have to the historical understanding of the meaning of insurrection during Reconstruction?
Well, these were well-known examples. I mean, probably the Whiskey Insurrection was better known because it was referred to in the 39th Congress. And, you can find books written about the Whiskey Insurrection in the run-up to the Civil War. And also one of the leading cases on sort of discussing insurrection arose out of Fry's Insurrection. And it was a case from 1800. So all of this would have been background that people would have been familiar with at the time.
These weren't obscure examples?
No, not at all.
I'm sorry, Professor, so when you say that informed what an insurrection was at a time, is that because the case law called them insurrections, or?
Well, yes, in part. The case of Fry's, for example, which arose out of Fry's insurrection, described it that way, as did President Adams' pardons of the individuals who were involved.
Okay.
And you've already touched on this, but did either of these examples rise to the level of a full-scale war or rebellion?
No.
You also mentioned that you looked at some dictionary definitions. Tell us what we're looking at here.
This is Webster's Dictionary from 1828.
This is on page 785 of your appendix. How did Webster's dictionary define insurrection at that time?
Webster's defined it as a rising against civil or political authority, the open and active opposition of a number of persons to the execution of law in a city or state.
And did Webster say anything about any difference between insurrection on the one hand and rebellion on the other?
Yes, it said that a rebellion was basically an attempt to overthrow the government or create a new government. I mean, people to some degree use those terms interchangeably because, as I said, Whiskey Insurrection is sometimes called the Whiskey Rebellion, but this definition defined them more starkly, differentiated them more starkly.
Was this the only example of a dictionary definition that you found informative?
No.
I want to pull up page 747 of your appendix. What is this?
This is a dictionary from 1848 by the Reverend John Bogue, who was a noted English lexicographer.
And why did you look there?
Well, because it is he was a noted person. I mean, not as famous as Noah Webster, obviously, but it had a definition of insurrection within it.
How did the definition in this dictionary compare to what we just looked at in Webster's dictionary?
It is essentially identical.
You also mentioned that you looked at cases defining insurrection. Tell us first a bit about how those cases came up.
Right, so prior to 1862, there was no crime of insurrection. So the only time that cases discussed insurrection came in treason cases when judges were instructing juries, giving them a charge on treason, and invariably they would discuss what insurrection was in those charges.
If we go to page 750 of your appendix, is this one such charge?
Yes.
And tell us the circumstances of this charge.
Okay, so this is a charge to a grand jury in the United States Circuit Court in Missouri in 1861. The way things worked then, Supreme Court justices would participate in trials to some extent, and so this grand jury charge was presided over by John Catron, who was the Associate Justice of the Court at that time.
If we go to page 752, I apologize, sometimes these historical sources are a little bit hard to read, but can you tell us how Justice Catron defined insurrection?
Yes, he said that the conspiracy and the insurrection connected with it must be to affect something of a public nature concerning the United States. And that included overthrowing the government or to nullify and totally hinder the execution of some U.S. law or the U.S. Constitution or some part thereof, or to compel its abrogation, repeal, modification, or change by a resort to violence.
And how does that inform your opinion here?
Well, I mean, that is an authoritative statement of law in 1861, close to the time when the 14th Amendment was ratified. And it is consistent with the dictionary definitions just seen, saying that an overthrow of the government was not required to have an insurrection. And it's consistent with the examples of the Whiskey insurrection and Fries' insurrection, where there was no attempt to overthrow the government. There was an attempt instead to resist the execution of law.
Was this instruction by Justice Catron an isolated example in the case law?
No.
Tell us a bit more about that.
Well, there are other treason cases from before the Civil War that had very similar language. So one I mentioned earlier was a case called Case of Fries, which was about Fries' insurrection, and then another called United States versus Hanway from the 1850s.
How did the charges in Case of Fries and Hanway compare to Justice Catron's charge here?
They're essentially identical.
You said you also looked at sources related to the laws of war. I want to pull up page 553 of your appendix. Tell us what we're looking at here.
So this is the legal code that was issued to the Union Army during the Civil War.
And why did you look at this source by Francis Lieber?
Yes, well, a couple of reasons. First is it was the authoritative sort of law of war that applied during the Civil War. And secondly, Francis Lieber was probably the leading legal scholar of his day, and so he's a particularly authoritative author or speaker on these kinds of questions.
On page 594 of your appendix, walk us through what Francis Lieber said constituted an insurrection.
He said that insurrection is the rising of people in arms against their government or a portion of it, or against one or more of its laws.
And how, if at all, in this source, did insurrection contrast civil war or rebellion?
Well, Lieber described a rebellion as simply a very large insurrection, although he then went on to say that often it involved an attempt to overthrow the government or to set up a separate government.
And again, how does this discussion by Francis Lieber inform your opinion as to the understanding of insurrection during Reconstruction?
Well, it's consistent with all the other sources that I looked at.
Can you tell us whether or not you saw any serious disagreement during Reconstruction about the meaning of the phrase insurrection?
No, I did not.
How have today's historical scholars addressed the definition of insurrection?
Well, of the ones who have addressed it recently, they have been in agreement basically with the opinion that I'm offering and these sources that you've seen. In particular, the draft paper by Professor William Bode and Professor Michael Stokes-Paulsen, and the work, again, the draft paper by Professor Mark Haber at the University of Maryland.
If we go back to the language of Section 3, I want to now turn our attention to the phrase insurrection or rebellion against the same. How, if at all, does the language against the same affect your opinion as to the historical understanding of Section 3?
Well, that the language limits the definition of insurrection for Section 3 purposes to one that is against the Constitution of the United States.
And so how does that limit or change the definition of insurrection?
Well, it eliminates a certain class of insurrections from things that would be considered for purposes of Section 3. So the most obvious example would be an insurrection against state or local law. That would not be a Section 3 insurrection because it does not involve the Constitution of the United States.
Does the historical record tell us anything about why Section 3 would be limited to a particular type of insurrections, namely those against the Constitution?
Okay, well, one is, again, they were concerned to limit the scope of the provision, right? And this is a way of doing that. And then second, there's a thought that since the oath was central to both sort of the limitation and the rationale, the oath that you take is to the Constitution of the United States. It's not to the United States generally. And so it makes sense to think that the insurrection you're concerned about, or rebellion, would be one against the Constitution that you swore an oath to support.
I want to draw our attention now to the language, shall have engaged in insurrection or rebellion. Does the historical evidence shed light on what it means to have engaged in insurrection, or how that would have been understood historically?
Yes, I mean, during Reconstruction, engaged in insurrection was understood broadly to include any voluntary act in furtherance of an insurrection against the Constitution, including words of incitement.
What sorts of historical sources did you look at in forming that opinion?
Well, I looked at judicial decisions. I looked at opinions of the United States Attorney General. Those were sort of the two leading sources that I looked at.
I want to pull up page 788 of your appendix. Tell us what we're looking at here.
This is an opinion by the United States Attorney General in 1867 interpreting the Military Reconstruction Acts of Congress.
Okay, and what's the historical significance of this opinion of the U.S. Attorney General interpreting the Reconstruction Acts?
Okay, this will take a minute to explain. So in 1867, Congress passed a series of measures that placed most of the former Confederacy under martial law. And in doing so, Congress ordered that these states hold new elections for conventions that would write new state constitutions and would ratify the 14th Amendment. Now, as part of the direction as to how these elections were to be run, Congress said that people who would be disqualified from office by the language of Section 3 of the 14th Amendment should not be allowed to vote in the elections for these new conventions. And the Union Army was tasked with enforcing this provision.
So just to back us up a little bit, this is May of 1867. Was that after Congress had submitted the 14th Amendment for ratification?
Yes, it was in the period between the submission of the amendment to the states and its ratification. So the statute refers to the proposed Section 3 of the 14th Amendment.
And to be clear, how did the language of the Reconstruction Acts compare to the language of the proposed constitutional amendment in Section 3?
It was identical.
Did this opinion of the U.S. Attorney General have any kind of legal effect?
Yes, it did. The opinion was approved by the Cabinet. We have the Cabinet minutes on that. And then was the basis for instructions that were issued to the Union Army commanders in the former Confederacy as to how they were to implement Congress's directive on these elections.
What form did the instructions to the Union Army take in terms of implementing the opinion of the Attorney General on the Reconstruction Acts?
Basically, there were instructions issued by the Secretary of War. Also, Ulysses S. Grant was involved because he was the general of the armies at the time.
Can you tell us whether or not those instructions included the language of this opinion?
They did.
So how would you characterize the historical significance of these opinions by Andrew Johnson's Attorney General?
Well, they are an authoritative interpretation by the Attorney General of the United States on the language that ended up being ratified in Section 3 of the 14th Amendment.
And who was the Attorney General at that time?
Sandberg.
I want to direct our attention to page 800 of your appendix. Walk us through what Attorney General Stanberry said about what it means to have engaged in insurrection.
Well, he described it as some direct, overt act done with the intent to further the rebellion. And then later he said that the act had to be voluntary because there was some concern about people who were drafted into the Confederacy that they not come under the disqualification because they had not acted voluntarily. So basically, a direct, overt act done with intent to further the rebellion, that was voluntary.
There's a discussion here of mere acts of common humanity and charity can't be considered as participating in the rebellion, or forced contributions can't be seen as participation, correct?
Correct.
Did the opinion of the Attorney General identify any other conduct in furtherance of insurrection or rebellion that would be considered outside the scope of Section 3?
No.
What does this source tell you about whether or not someone would have needed to have taken up arms in order to have been understood to have engaged in insurrection at this time?
It was not required.
Let's go to page 804 of your appendix. Tell us what we're looking at here.
Well, this is a second opinion that the Attorney General issued because, remember, the Army had never organized an election before, so the Union Army commanders requested additional guidance from the Attorney General as to how to do this. So a second opinion was issued.
Does this second opinion have any historical significance?
Yes, again, it was approved and used as a basis for instructions to the Union Army commanders.
If we go to page 815, walk us through what this second opinion of the Attorney General tells us about what it meant to have engaged in insurrection.
Well, again, here it says that it must be an overt and voluntary act done with the intent of aiding or furthering the common unlawful purpose, namely the insurrection. And then that voluntary contributions, even such indirect contributions as arise from a loan of money or the purchase of bonds, would count for disqualification.
And so again, what does that tell us about whether or not Section 3 was understood to apply only to those who took up arms against the Union?
It did not apply only to those who took up arms.
Later in that page, what did Attorney General Stanberry say about speech?
Well, he said that disloyal sentiments, opinions, or sympathies would not disqualify, but when a person has, by speech or by writing, incited others to engage in rebellion, he must come under the disqualification.
Now, we've seen this discussion in the Attorney General's opinion about a voluntary act in furtherance of the rebellion. Tell us how early judicial cases compared to this discussion in the Attorney General's opinion.
They are consistent.
If we go to page 203 of your appendix, what is this case?
This is Worthy versus Barrett, one of the North Carolina cases that I referred to earlier,
And when was this case decided?
1869.
On the second page, what does the Worthy Court say about what constitutes engaging in rebellion?
Well, a voluntary act by personal service or by contributions other than charitable of anything that was useful or necessary.
How did that compare to what we just looked at from Attorney General Stanberry?
It's essentially the same.
Were there any other cases addressing this language at this time?
Yes, there was a federal case in North Carolina in 1871, United States versus Powell, that again said that a voluntary act in furtherance of insurrection or rebellion was the definition of engaged in insurrection.
Were there any cases at this time that disagreed with Attorney General Stanberry's opinion that words of incitement were enough to have engaged in insurrection?
Not that I'm aware of, no.
In your report, you also discuss some pre-Civil War cases on the law of treason. Why did you look at those cases?
Well, as I mentioned earlier, the only time that judges discussed insurrection before the Civil War came in treason cases, so naturally I wanted to look at those.
Do those cases, those treason cases from before the Civil War, shed any light on this question of whether or not someone needed to have personally taken up arms in order to have levied war against the government or engaged in insurrection?
Yes, they make clear you do not need to take up arms to be engaged in levying war. You could do so by encouraging or instigating an insurrection.
And did those cases specifically address this issue of instigation or incitement?
Yes, they do.
And you touched on this a minute ago, but walk us through kind of what those cases said about incitement.
Well, I mean, basically they said that just because you had not been on the scene of the violent event, or that you had sort of not taken up arms, that didn't matter. That what mattered was basically you could be engaged in an overt act supporting treason if you instigated, incited, and encouraged that activity.
During Reconstruction and during the Civil War, did Congress ever address this issue of disqualifying insurrectionists?
Yes, so as I mentioned earlier, if a member-elect showed up to the House of Representatives or the Senate, there could be a challenge about whether that person was involved in the Confederacy, and then each House of Congress would have to assess whether their involvement was qualified.
Let's turn to page 463 of your appendix. What is this historical source?
This is Heinz Precedents of the House of Representatives, which is an authoritative source of decisions by individual houses of Congress running through the 18th and 19th centuries.
Why did you look at Heinz precedents?
Well, this is where you would look for precedents from individual houses of Congress as opposed to, say, legislation or judicial precedents.
Tell us a bit about the case of John Young Brown.
Yes, so John Young Brown was a member-elect to the House of Representatives from Kentucky, and when he arrived in 1868, he was challenged on the ground that he had given aid to the Confederacy.
Let's look at page 465 of your appendix. And I want to pull up some language here. What are we looking at here?
This is essentially a letter to the editor that Mr. Brown wrote early during the Civil War, in which he advocated the violence against Union troops that might enter Kentucky.
And was there any argument in the case of John Young Brown that he had done anything to aid the rebellion other than this letter to the editor?
No, this was all that he was accused of doing.
How did Congress decide the case of John Young Brown?
They did not see Mr. Brown.
On what basis?
That he had been involved with the Confederacy and was disqualified.
Now, you said this case was in 1867, correct?
1868.
1868? Was that before or after Section 3 had been ratified?
It was a little bit before Section 3 was ratified, so it was not a Section 3 enforcement, strictly speaking.
So on what basis did Congress say that Mr. Brown was disqualified?
Well, the House has broad power to disqualify or refuse to seat members-elect, especially in that era. And so basically they said that he had given aid to the Confederacy through this editorial.
If the case of Mr. Brown was not a case applying Section 3 itself, why did you look at it in informing your understanding as to the scope of Section 3?
Well, because this decision was taken in the year that the 14th Amendment was ratified, and it concerned the kind of conduct that would be considered disqualifying. So it seemed informative as an example for what people might have been thinking about when the provision was subject to ratification.
Did you look at any other congressional cases of disqualification or exclusion?
Yes, there was one other case in 1867 of Philip Thomas. Mr. Thomas was a senator-elect from Maryland, and he had given $100 to his son before his son went off to join the Confederate Army, and he was challenged on the grounds that he had given aid to the Confederacy by doing that.
Have you done anything other than give $100 to his son when his son was leaving to join the Confederate Army?
No.
How did Congress address the case of Philip Thomas?
They did not seek Mr. Thomas.
On what basis?
That he had given aid to the Confederacy that was disqualified.
Same question as with Mr. Brown. Was that a Section 3 case?
No, it was not, because it came in 1867, a year before the 14th Amendment was ratified.
And did you still consider that to be relevant in understanding the historical backdrop to Section 3?
Yes, for the reasons I just identified, that it happened while Section 3 was pending before the states and concerned what kind of conduct would be considered disqualifying from office.
You've mentioned historical sources discussing a voluntary act in support of insurrection by words or deeds. Did the issue of inaction ever come up? Were there any cases where an individual was charged for having abdicated a duty to protect the Constitution?
No.
So does the historical evidence kind of tell us anything one way or another about whether they saw any kinds of inaction as potentially being covered by Section 3?
No.
But if we step back and look at all the historical sources that you've just discussed, what do those sources tell us about whether or not an individual is disqualified or was understood to be such at the time without having taken up arms against the government himself or herself?
Well, the answer is you could be disqualified without having taken up arms against the government in the period of the Civil War.
I want to move now to a discussion of offices and officers. Set the table for us a little bit about how those terms come up in Section 3.
Sure. Well, Section 3 says that no person shall hold any office, civil or military, under the United States or under any state, if they have taken an oath as an officer of the United States, among other things, to support the Constitution of the United States and then have engaged in insurrection against the same.
So to be clear, first you have to have taken an oath as a qualifying official or officer of the United States and then engaged in insurrection?
Correct.
And if you've done that, if you've taken an oath as an officer and engaged in insurrection, then what kinds of offices or positions are you disqualified from at that point?
Right. That's right. So the first portion describes the offices and the second portion describes the officers.
Have you looked at historical evidence bearing on the question of whether the office of the presidency was understood to be an office under the United States such that a disqualified individual could not take that office?
I have.
And what is your opinion on that question?
My opinion is that during Reconstruction, the presidency was considered an office under the United States for purposes of Section 3.
And have you looked at historical evidence addressing whether or not the president during Reconstruction was considered as an officer of the United States?
I have.
And what is that opinion?
My opinion is that during Reconstruction, the president was considered an officer of the United States for purposes of Section 3.
In addressing the meaning of officer and office, what kinds of historical evidence did you look at?
So I looked at congressional debates and reports, I looked at presidential documents, I looked at opinions of the United States Attorney General, I looked at judicial decisions, contemporary newspapers, what means.
Did historical sources at this time define, in the context of Section 3, what it meant to be an officer of the United States?
Yes, they did.
And what did they say you had to do in order to be an officer of the United States?
Well, the main thing was that you had to have taken an oath to support the Constitution. That, again, the oath was central to the text and the purpose, and was also considered pivotal to the question of whether you were an officer or not.
If we go back to the North Carolina Supreme Court's decision in Worthy, was this one of the cases on this issue that you were mentioning earlier?
Yes.
What did the Worthy Court's decision tell us about who is an officer?
Well, the court said that it did not know how better to draw the distinction between an officer and a mere placeman, and say an employee, than by making his oath a test. And then went on to say that every officer was required not only to take an oath of office, but an oath to support the Constitution of the state and of the United States.
Did Attorney General Stanberry ever address this issue as well?
Yes, he did in one of his opinions that we looked at earlier.
If we go back to the first opinion of the Attorney General on page 797 of your appendix, walk us through what Stanberry said about officer of the United States under the language of Section 3.
Well, he said that the term is to be used in its most general sense and without any qualification, and that the oath was central to determining whether someone was an officer or not.
And how did Attorney General Stanberry's opinion that officer is used without any qualification relate to your opinion as to whether the presidency was understood to be covered at this time?
Well, there was no qualification for the President of the United States.
I want to ask you briefly about an argument that's been made in this case, that the President's oath under Article 2 to preserve, protect, and defend the Constitution of the United States is not, for purposes of Section 3, an oath to support the Constitution of the United States. Are you familiar with that line of argument?
Yes, I am.
Have you seen any historical evidence that bears on the question of whether the President's oath to defend the Constitution would have been understood to fall under Section 3?
I have.
I'm pulling up page 869 of your appendix, and I apologize, this is another one of those hard-to-read historical sources, but what are we looking at here?
This is a grand jury charge that was issued by a federal circuit judge in Tennessee in 1870, and it was reprinted in a newspaper.
Well, why are we looking at a newspaper here?
Well, because in those days, grand jury charges were often reprinted in newspapers as a kind of exercise in public education, as well as just to tell people what was going on in the courts.
And who originally identified this historical source?
I did.
Okay. What did this charge tell us about oaths in Section 3?
Well, Judge Emmons said, the oath which shall have been taken need not be in the precise words of the amendment, quote, to support the Constitution of the United States. He went on to say that there were slight differences in the forms of the oaths that people took, but the important thing is whether they include, substantially, even if not literally, an obligation to the federal power, and that the jury was not to consider the argument that, in fact, the wording of the oath did not include the word support.
How does that relate to your opinion that the oath that the President swears to defend the Constitution is covered by Section 3?
It leads me to the conclusion that it is covered because the difference in wording is irrelevant.
Did you also consider any presidential proclamations in addressing whether the President was considered to be an officer of the United States at this time?
I did.
And tell us a bit about those proclamations.
Well, these are proclamations that were issued by President Andrew Johnson, who was the president at the time that the 14th Amendment was ratified, in which he explained how he had the authority to create provisional governments in the Confederacy following Lee's surrender to Grant.
If we look at page 442 of your appendix, is this one of those proclamations?
Yes, it is.
Tell us a bit about the context here.
Yes, well, the president is issuing, in effect, an executive order, they call it a proclamation, where he's establishing a government in one of the former Confederate states, and he justifies that on the grounds, in part, that he is the chief civil executive officer of the United States.
And remind us what year this was.
This is 1865.
So shortly before Section 3 of the 14th Amendment was adopted?
Yes.
Was this an isolated example of President Andrew Johnson?
No, he issued the same proclamation for different states throughout the Confederacy, and these proclamations were widely reprinted in newspapers at the time because they were setting forth the terms of the governments that were to govern in several states of the United States.
Was Andrew Johnson the only president in the 19th century to refer to himself as an officer of the United States?
No, President John Tyler in the 1840s referred to himself as the chief executive officer, and President James Buchanan, who was Lincoln's predecessor, referred to himself as the chief executive officer under the Constitution.
In your report, you also talk about examples of how this issue came up in Congress. Tell us a bit about that.
Yes, well, there were references to the president as either the executive officer of the United States or an executive officer of the United States in Congress multiple times during the Congress, either that proposed the 14th Amendment or the one that oversaw its ratification. I
want to look at page 488 of your appendix, an excerpt from the Congressional Globe. What are we looking at here?
This is a speech by John Bingham in 1868 in which he describes the president as the executive officer of the United States.
And remind us what John Bingham's role was in the adoption of the 14th Amendment.
Well, he was the principal drafter of Section 1 of the amendment, and he was a member of the Joint Committee on Reconstruction, which was sort of the pivotal committee that essentially assembled the proposal of the 14th Amendment more generally.
Tell us about some of the other contexts in which this issue of the president as an officer of the United States came up at this time.
Yes, well, it was also addressed in President Johnson's impeachment trial, which occurred in 1868, shortly after the speech that Bingham gave, in which the president's own lawyer described him as an executive officer of the United States. The president has different formulations, whether executive officer of the United States, the executive officer of the United States, and one of these mere executive officer of the United States by various members of Congress, including Bingham on at least one other occasion.
Let's look at page 811 of your appendix. This is from the second opinion of Stanberry on the Reconstruction Act. And what did he say on that issue?
Well, he said that the president, who was his boss, is simply an executive officer.
Did anyone at the time specifically address the question of whether Section 3 covered the office of the president?
Yes.
How did that come up?
That came up during the Senate debate on the Section 3 language.
I'm pulling up page 477 of your appendix, excerpts from the Congressional Globe from that time. Walk us through how that issue came up in the debate about Section 3.
So a question was posed as to why the president or the vice president was not specifically mentioned among the offices listed in Section 3. And Senator Locke Morrill of Maine, who was a supporter of the 14th Amendment, said, well, let me call the senator's attention to the words, hold any office, civil or military, under the United States. And then the response to that was, in effect, oh, yes, I'm sorry about that, never mind. When I first saw this excerpt in 2020, when I was researching the original article, it was very exciting because you rarely get such a clear statement of legislative history, right? Normally legislative history is about things that you're not particularly interested in, or they're more vague in their phrasing. This is about as specific as you can get.
Were you the one who dug this up?
Yes.
Did anyone come back later in the debate and say, actually, you were wrong, we are excluding the presidency from Section 3?
No.
Talk to us a bit about how Jefferson Davis came up in the debates around Section 3.
Well, there was a consensus at the time that Jefferson Davis was ineligible to be president because of Section 3. And when Congress considered granting amnesty to individuals, an objection to granting amnesty to everyone was that, well, that would give Jefferson Davis amnesty, and that meant that he would then be president of the United States, which people thought was just unacceptable.
And when specifically did that issue of kind of amnesty, including Jefferson Davis, come up in these debates?
Well, it came up more, it was discussed a little bit during the time that the 14th Amendment was under ratification, pending, but it really came up more when the debate on amnesty heated up in the 1870s, around the time of the General Amnesty Act in 1872, and then again in a debate in 1876 when they were thinking about giving amnesty to the remaining few hundreds of people who had not been given amnesty in 1872.
In the discussions about amnesty that might allow Jefferson Davis to become the president again, describe kind of the tone of the supporters of Section 3 at that prospect.
Well, they thought it was kind of preposterous that Jefferson Davis could be eligible to be president of the United States, and they insisted that the only way that would happen is if he were given amnesty.
Can you tell us whether the historical purpose that you've identified behind Section 3 tells us anything about whether or not the president was understood to be excluded?
Well, yes, in the sense that it would have been odd to say that people who had broken their oath to the Constitution by engaging in insurrection were ineligible to every office in the land except the highest one.
Did the debates ever talk about kind of high office versus sort of lower level officials in the context of Section 3?
Yes, there were references in the Senate to the fact that in part the idea of Section 3 was to go after people who were the most responsible for secession and civil war, and that tended to include higher level officials. They were seen as basically more blameworthy for what had happened than, say, lower level officials.
I want to ask you just a few final questions. Last Friday, Trump served an expert report in this case by Robert Delahunty. Have you had a chance to review that expert report?
I have.
Describe for us your level of familiarity with the people who today are recognized as experts on Section 3.
I'm very familiar with them.
When was the first time you had ever heard of Robert Delahunty?
When I learned that he would be an expert witness in this case.
How would you characterize Robert Delahunty's contributions, if any, to the scholarly debate on the history of Section 3?
I don't know of any.
Is Robert Delahunty someone that you would consider to be an expert in this history?
No.
Robert Delahunty cites an article, a law review article.
I'm going to object to this entire line of questions. This was not part of his expert report. It's totally improper.
Your Honor, we got his expert report at midnight on Friday, and I understood that we were able to do short rebuttal or response to that since we did not have a chance to respond in writing.
Your Honor, he may contend with Professor Delahunty's arguments if he sees fit, but he is not an expert on Professor Delahunty's expertise. He is not here to render an opinion on whether he's a better expert than Professor Delahunty is a better expert, or Professor Delahunty is a better expert. So, I understand some experts think they're... No, I want some more opinion.
The court also stated an objection to the extent that I agree. I don't think it's proper for one witness to comment on the other witness's expertise. That's what you do in cross-examination. However, I will allow the professor to talk about his response to the opinions of Professor Delahunty. Is that the correct name?
Yes, sir.
Thank you, Your Honor. One of the sources that Professor Delahunty relies on is an article by Professors Blackman and Tillman on the question of whether or not the presidency is an office under the United States. Is that an article that you're familiar with?
I am.
Can you situate that article in the broader scholarly debate surrounding the history of Section 3?
Well, I mean, of the draft papers that have considered the question of whether the president is an officer of the United States for purposes of Section 3, and there aren't that many, I would say that their position so far is in the minority.
Tell us who some of the other scholars are who have addressed this issue and disagreed with the Blackman and Tillman position.
Yeah, so there's the draft paper by Professors Bogue and Paulson that I mentioned earlier, the draft paper by Professor Graeber that I referenced earlier. There's another draft paper by John Vladimos, I believe is the correct pronunciation of his name, and they all take the view that the president is an officer of the United States for purposes of Section 3, as I do.
I want to ask you about a few other sources that are cited in Mr. Delahunty's expert report. I want to pull it up on the screen here. Petitioner's Exhibit 227. If we go to page 10, there's a discussion of the presidential election of 1872 and the candidacy of Horace Greeley, which I think was also referenced in opening statements. Have you reviewed this portion of Mr. Delahunty's report?
Yes, I have.
And tell us what you understand to be the argument about Horace Greeley in 1872.
Well, I understood the argument to be that Horace Greeley ran for president in 1872 as a Democratic nominee, and no one objected to that on the grounds that he was ineligible to do so under Section 3, and that therefore that might mean that Section 3 does not apply to the presidency.
Do you agree with that argument?
No.
Why not?
Horace Greeley was not a Confederate. He was a loyal supporter of President Lincoln during the war. He was a supporter of radical Republican policies during Reconstruction early on. He was a supporter of the conviction of Andrew Johnson in the impeachment trial in 1868. Section 3 had nothing to do with him.
Didn't anybody kind of criticize him for Southern sympathies, though?
Yes, but I mean, that was just sort of political rhetoric that people were putting out. And, you know, there's a distinction between that and the sort of legal ineligibility that would attach to Section 3. Now, for example, John Bingham gave a speech in 1872, a campaign speech against Greeley. He was campaigning for Grant's re-election. And he expressly distinguished Horace Greeley, whom he opposed, but basically he could be president if he won, from Jefferson Davis, who he said could not be president because of Section 3 of the 14th Amendment unless Davis got amnesty. So it was pretty clear. Davis was a Confederate. He was ineligible. Greeley was not a Confederate. He was eligible.
And let's, I know you said that Horace Greeley was not a Confederate and so wasn't covered by Section 3, but let's assume for the sake of argument that he was otherwise covered by Section 3. What, if anything, does the state of amnesty by the time of the 1872 election tell us here?
Well, if Greeley had been covered by Section 3, he would have received amnesty under the General Amnesty Act that was enacted in the spring of 1872. So it wouldn't, Section 3 couldn't have applied to him anyway while he was running for president.
Does the example of Horace Greeley tell us anything here?
No.
There's also a discussion in Mr. Delahunty's report citing to an article by Professor Kurt Lash about earlier drafts of Section 3 of the 14th Amendment and whether those shed any light on whether the presidency is covered. Are you familiar with those arguments?
Yes.
And what is your opinion on those arguments from a historical standpoint?
Well, they're inconclusive, right? That is to say, you can't draw a conclusion from early drafts as to what the final draft means unless somebody says, the reason we're changing the draft from this to that is because of something. So nobody made any such commentary about the differences between early drafts and the final draft. I mean, it would be nice if we had more information about the drafting and ratification of the 14th Amendment, but we have what we have. And so therefore, you really can't draw any conclusion about the final draft from any of the earlier drafts.
Is there any indication that you've seen in any of the congressional debates about Section 3 that anyone intended to exclude the president or the presidency?
No.
I want to turn to page 30 of the report. There's a discussion here of 3 sources identified by Professors Blackman and Tillman that they cite to suggest the president is not constitutionally an officer of the United States. Did you review that portion of Mr. Delahunty's report?
I did.
Were those historical examples persuasive to you?
No.
Why not?
Well, a couple of reasons. I mean, first of all, they all arise a decade after the ratification of the 14th Amendment. They are not about Section 3, that's the second reason. Now, third is, I don't know who David McKnight was. But put another way, he's not Noah Webster or Francis Lieber, so he doesn't have the same sort of authority. So the statement in his treatise is of only very limited importance. The other 2 statements came out of the Senate impeachment trial of Secretary of War William Belknap. He was accused of corruption, among other things. And the thing is that, first of all, that was a trial that was not about the president. So the statements by the senators that the president was not an officer of the United States were kind of dicta, basically, that had nothing to do with the trial that they were involved in. Now, let's contrast that with the statements about this issue in the impeachment trial of Andrew Johnson. Now, that happened in 1868 when the 14th Amendment was ratified. That was about the president. He was on trial. People did say that he was an officer of the United States. His own lawyer said it, as well as members of the of Congress. And it was an actual issue in the trial. And the reason for that is that President Johnson was accused of committing a high crime and misdemeanor by refusing to follow an act of Congress because he thought it was unconstitutional. Okay, so set aside what you think of that argument. Part of making that argument meant saying, well, he wasn't a judicial officer, and only judicial officers can set aside laws because they are unconstitutional. He's only an executive officer. So that was part of the reason why people were describing him as an executive officer or the executive officer. So it was actually related to the issues under discussion in a way that, of course, these statements that you see here in the Secretary of War's trial some years later were not. So I just think, well, it's not persuasive evidence on the question.
I want to briefly ask you about Professor Delahunty's argument that Section 3 is too ambiguous for courts to decide without congressional implementing legislation. Do you have a view on that issue from a historical standpoint?
Well, yes, first of all, we see examples of people applying Section 3 and interpreting it at the time. Right? And so, in the end, it's really no different than a lot of other legal standards, which are broad, and you have to figure out how to apply them to a particular set of facts. But that's what we do with standards like that. Now, it would be nice if we had more examples, more cases to guide us. But I had a colleague, he was no longer with us now, but when people would say, why don't we have more information before we make a decision, she'd just look at me and say, alas, you know, like we have what we have, but we have to work with what we have. But there's no reason to think that we can't work with what we have.
Do you agree with Mr. Delahunty's argument that the phrase insurrection was ambiguous at the time?
No, I mean, we've gone through quite a bit of material to define what insurrection was, and you know, that doesn't mean we know how it should be applied to every set of facts, but there's quite a bit of material that defined what insurrection was as of Reconstruction.
Do you agree with Mr. Delahunty's argument that the phrase engaged in insurrection does not include speech?
No, I do not.
Mr. Delahunty cites the Second Confiscation Acts in making that argument. Can you explain to us what the Second Confiscation Acts were and kind of what you understand that argument to be?
Sure. The Second Confiscation Act was a criminal statute enacted in 1862 that defined insurrection by listing a series of terms, including to set afoot, to incite, to engage. And then my understanding is the argument is, well, Section 3 did not include the word incite in its terminology in the way that the Second Confiscation Act did, so therefore maybe incite was not included by Section 3.
Do you agree with that argument from a historical perspective?
No.
Why not?
Well, first of all, I think there's a difference between a criminal statute, which is what the Second Confiscation Act was, and the provision of Section 3, which is creating a new qualification for office. So the comparison is not that close. Secondly, there's no explanation in the debates on Section 3 as to why the word incite was not included. So again, it's like you can't really draw conclusions from a prior version, right, as compared to a final version, unless you know something about why there's a difference. Thirdly, constitutional provisions are not statutes. They are not as specific as statutes. They're written in general language. That was well understood at the time. Chief Justice Marshall explained this in his opinion for the court in McCulloch versus Maryland, that you can't make constitutions as specific as statutes because then they would be incredibly long, incredibly hard to understand for average people. So, you know, constitutional provisions like Section 3 were written in general terms.
What, if any, conclusion do you draw from the fact that Section 3 does not specifically mention incitement?
I don't draw any particular conclusion from it. I draw conclusions from the other sources that interpreted Section 3, namely the Attorney General's opinions.
My last question for you is, if we step back and evaluate Professor Delahunty's historical methodology laid out in his report as a whole, what is your opinion as to the reliability of his historical method?
Your Honor, we will object.
Sustained.
Professor Magliocca, you discussed earlier the types of historical methodologies that scholars in history typically follow when they are deciding historical questions, correct?
Yes.
And can you tell us whether or not, in your view, Mr. Delahunty followed those prescribed methodologies?
Your Honor, objection again. And further, we know that Mr. Magliocca has not been, Professor Magliocca has not been proffered as an expert on historical methodologies.
Sustained. You can talk about his methodologies, but you can cross-examine Professor Delahunty on his.
Understood, Your Honor. We don't have any more questions. Thank you.
Cross-examination.
Good morning, Professor Magliocca.
Good morning.
You may proceed.
Sure.
You've been on the witness stand before, correct? In the Georgia case, if I remember correctly? Okay. Have you been a witness in any other instances?
No.
Okay. So you know how this works with me asking you a few questions. And thank you for being here today. So I want to ask a little bit about sources. You'd agree with me with respect to the 14th Amendment in Section 3 that there's recently, within the past few years, a substantial amount of new scholarship on that issue.
Yes.
Okay. And you mentioned that your view that the Tillman and Blackman viewpoint is in the minority, correct?
Yes.
Okay. And you would agree with me that when courts make decisions on interpretation, they don't count up the number of professors on one side of an issue versus the number of the other side and make their decision on that basis?
Well, no, it's not the only factor.
Well, it's probably not even one factor. They look at the strength and the quality of the underlying arguments, correct?
Yes.
Okay. Now, you and I had chatted just very briefly, and you're familiar with Professor Blackman, correct?
Yes, I know him and I like him.
And you two have mutual admiration for one another and mutual respect for one another's scholarship?
Yes.
Okay. And you still have some pretty sharp disagreements on the meaning and application of Section 3. Is that fair to say?
Yes.
Okay. And it's fair to say that you two will continue to have discussions, continue to disagree, perhaps sometimes resolve your disagreements as part of the scholarly and analytical process.
Probably later today.
He may even be listening to your testimony today.
Could be.
Okay. And then you'd agree with me that that scholars such as yourself and others will continue to analyze the historical record and sometimes modify your opinions based on what you find, correct?
Yes.
Okay. And in fact, there's one instance where Professors Bode and Paulson quoted the historical record of the case of Jefferson Davis. Are you familiar with that?
Yes.
Okay. And Professors Tillman and Blackman looked at the history very closely and said the actual record, this record written with respect to Justice Chase's ruling, was incorrectly recorded. Do you remember that?
Well, they made the argument that it was incorrectly recorded.
Okay. And so what they did is they compared an 1869 version from American Law Review to an 1894 version and said, look, the 1894 was essentially that sentence with respect to Section 3 was inserted, we believe, incorrectly.
Well, yes, now that's a bit more complicated in the sense that, I mean, first of all, it's not clear that it was inserted incorrectly, because if you look at newspaper commentary at the time, I mean, there was somewhat of a mixed set of views about what Chief Justice Chase was saying in that case or thought about it. Secondly, it was actually pretty common practice back then for comments to be inserted in official reports years after the fact. In my book on Bush Roy Washington, he would revise his reports, or he had someone who helped him edit them, years after the fact to change them. And so today, you didn't have an official set of reporting systems the way we do now, right? So today that would seem improper or very odd, whereas back then it was more common. So yes, but they made that argument. Right.
And so the point I'm trying to make, and I'm assuming you will agree with me, but I'll ask you if you agree with me, that there's still substantial debate about the accuracy or the quality of the historical record in some instances with respect to Section 3.
Yes.
Okay. And you'd agree that you have a pronounced point of view and some other scholars have different points of view on that issue?
Yes.
Okay. Now, my understanding is that you have not rendered an opinion, nor have you been asked to render an opinion on the meaning of the word incitement.
That's right.
Okay, or incite, or any variant of that.
Right.
And so your argument is that insurrection can include words of incitement.
Yes.
But you're not necessarily defining what incitement is.
Correct. I'm not a First Amendment expert.
Okay. Excuse me one moment. Could you do that water too, please? And is it, just to understand sort of your definition of insurrection, in order to engage in insurrection, in your view, does that require an overt and voluntary act?
Well, an overt or voluntary act would constitute engaging in insurrection. I mean, whether inaction could, it's just not something that was addressed, so history doesn't tell us the answer.
Okay. Could someone engage in insurrection with an involuntary act?
No.
Okay. Could someone engage in insurrection with a secret act?
Well, no, in the sense that there had to be some public action that was involved, probably in the sense that there was a public use for a public purpose to the insurrection.
Okay.
Yeah, I would tend to think not.
So you'd agree with me that it requires an overt and voluntary act?
Well, an overt and voluntary act would qualify. Yes.
Okay. And that someone has to have a specific intent.
Well, that's a question on which the sources don't give us a clear answer. The Attorney General's opinions do refer to intent. On the other hand, the cases don't. The cases, to some degree, could be understood as saying that awareness or knowledge is sufficient. The reason I say that is because, let's say you had a sheriff, in a southern state. They were the sheriff before the Civil War. They maintained the same position during the Civil War and after the Civil War. So they were doing the same job the whole time. All that changed is, they were in the United States, they were in the Confederacy, they were in the United States. It's not clear there's any intent involved, but they would have been disqualified because they had served prior to the war. Now they're serving during the war. Now they're still there after the war. It is clear that they were aware of the insurrection, right? But they were just doing the same job in the same way. So it's less clear that would constitute intent.
So let me ask you, because there's a couple branches of Section 3, right? There's the aid and comfort to the enemy's branch, and there's the engage in insurrection or rebellion.
Yes.
Okay. So are you saying it's unclear whether or not that sheriff engaged in insurrection? Or
the sheriff was deemed to have engaged in insurrection.
Okay.
My point was you can't say that there's any specific intent involved there.
Okay.
That would know.
Because he was exercising civil authority under the government of the Confederacy.
In the same way that he did before and afterwards. Yes.
Okay. Are you familiar with Professor Kurt Lash? Well, you are familiar with Professor Kurt Lash. You two have, I think, either written an article together or served on a panel?
We did a podcast together. Yes.
Okay. And he recently wrote an article sort of talking about the historical record of Section 3, correct?
Yes.
And you agree with me that he uncovered some aspects or some items within the historical record that were relatively new to scholarship?
Well, I think every draft paper is able to do that, yes.
And that's just part of the advancement of scholarship. Each draft paper adds new information.
Right.
Okay. And have you been in correspondence or spoken with Professor Lash since he wrote his paper?
I have, yes.
Okay. And that's a collegial relationship similar to the one you share with Professors Tillman and Blackman. Would that be fair to say? Okay. Could you excuse me 1 second, Aaron? Let me just ask you one more question, or just another set of questions on the First Amendment issues. The word within sight. So did I correctly hear it saying that you're not here today as an expert on the First Amendment?
Correct.
Okay. So you've not, for purposes of today, maybe at some other point, sort of done an analysis of what incitement means or the historical record behind
No,
that?
there were no First Amendment cases from the Supreme Court until well after Reconstruction, so that's part of the reason why.
Okay. So basically, the historical record you've looked at predates modern First Amendment law.
Correct.
Okay. All right. I have no further questions. Thank you very much.
Very briefly, Your Honor.
You were asked about Professor Kurt Lash. You remember that?
Yes.
Have you reviewed Professor Lash's draft paper on Section 3?
Yes.
Can you tell us whether anything in that draft paper changed or affected your opinion on what insurrection would have been understood to mean at the time of Reconstruction?
No. He didn't really address that very much.
Can you tell us whether or not anything in Professor Lash's paper changed your opinion as to what kinds of conduct was sufficient to have engaged in insurrection?
No, he didn't really address that much either.
Can you talk to us just very briefly about what the time period was that Professor Lash looked at?
Well, I mean, he was mostly looking at 1866 to 1868, although he did talk about a few other things, including, of course, really the example that Professor Delahunty also referred to in his expert report.
Can you tell us whether or not, in your opinion, the time period he looked at in his article was sort of the whole body of historical evidence?
Well, I mean, mostly but not identically, right? That is, in other words, the time period that we're really all looking at is pretty much between 1865 and 1872 when Congress passed the general amnesty. I mean, there may be one or two things after that, but very little. So his paper covers, much of that period, though not, I would say, not certain things that came kind of towards the latter end of that period.
Thank you, Your Honor.
Does the Colorado Republic Party have any questions for Professor Magliocca?
We have no questions. Thank you.
No questions, Secretary.
Okay. Professor Magliocca, thank you so much for your testimony.
Good morning, Your Honor. Our next witness is Hilary Rudy, and she is not in the courtroom yet. She is walking over at this very moment.
Okay, why don't we take a break then, go a bit early and reconvene at 10:15.
Okay, thank you.
You may be seated.
Are we ready to go?
Yeah. Oh, I'm sorry, I didn't even see that. Will you raise your hand, please? Do you swear under penalty of perjury that the testimony you will provide this court is the truth, the whole truth, and nothing but the truth? I do. Great.
Good morning. Could you introduce yourself, please?
I cannot hear you
Oh.
very well, so if you could.
Can you hear me better now? Okay. Here we go. I'll lean in. Could you introduce yourself, please?
Yes, good morning. My name is Hilary Rudy. I'm the Deputy Elections Director in the Colorado Secretary of State's Office.
And how long have you held that position at the Colorado Secretary of State's office?
Since 2013.
And did you hold a different position or different positions before that position at the Colorado Secretary of State's office?
I did. Prior to that, I held a couple of different positions in the legal team.
And so when did you first start working at the Secretary of State's office?
I began working as a full-time staffer in 2006,
And how many different Secretary of States have you served with?
including my internship in 2005 to 7.
And what political affiliation were those Secretaries of State? Were they mixed or all one, the other?
Mixed, both Republican and Democratic secretaries.
And you've not spoken to anyone on our legal team prior to your testimony today or in preparation for today, correct?
That's correct.
And have you testified in your role as Deputy Elections Director for the Secretary of State previously?
I have.
How many times?
I don't know the exact number, but several.
In your present role, what are your duties generally?
Generally speaking, I oversee the teams within the elections division that provide support, training, and oversight to the county clerk. So that would be the teams that oversee ballot access, the legal team, the state by voter registration system, county support, training, primarily the public-facing and county-facing portions of the division.
Can you describe generally what role the Secretary of State's office has in the administration of elections in Colorado?
Yes, so in Colorado, the Secretary of State is the chief election official for state and federal elections, and our role is to certify the content for state and federal offices to ballot, to certify to county clerks, to oversee the county clerks in each of Colorado's 64 counties in running elections to ensure that they comply with all of the legal requirements, to provide training and support in that, and just to generally ensure that they have what they need to run the elections and then certify the results for statewide contests.
Okay. I'm going to ask you a couple questions about some of those roles, but first, in the Secretary of State's role in administering elections, what role do the courts play in that process?
So the Secretary makes decisions with respect to candidate access to the ballot, with respect to certifying results, with respect to a lot of things around the election, and there is a role for the courts when somebody wants to protest a candidate's qualifications, protest the outcome of an election. There's a role for the courts at various parts throughout the elections calendar to basically make a decision if somebody is protesting a determination made by the Secretary of State.
And once a court makes a decision, what does the Secretary of State's office do with that decision?
Well, once a court has made a decision, then the Secretary's office conforms to that decision. So if the court decides that the Secretary decided incorrectly at the outset, then the Secretary's office will correct that. Or if the Secretary's decision is affirmed, then we will move forward with whatever that determination was.
And is there a particular statute that people challenging a decision of the Secretary of State often use to present issues to the court?
Well, there are a number of statutes that allow for a challenge of the Secretary's decision throughout the Title I of the Colorado Revised Statutes. Depending on how near we are to particular election deadlines, typically Section 113 is used to challenge something that needs to be decided quickly. Okay. And for demonstrative purposes, I'm going to pull that statute up and ask you some questions about it. Could you pull up Colorado Revised Statute 11113? And I particularly just want to start with Section 1. First, let me ask you, how familiar are you with Colorado Revised Statute 11113? I'm very familiar. I don't have it memorized, but I'm aware generally of what it says. And you're a lawyer by training, correct? I have a law degree, but I don't practice. Right. In 11113, I just want to ask you a couple of questions about some of the provisions in Section 1. So, do you see Section 1 there on the screen? Yes. So it says, when any controversy arises between any official charged with any duty or function under this code and any candidate or any officers or representatives of a party or any persons who have made nominations, or when any eligible elector files a verified petition in a district court of competent jurisdiction alleging that a person charged with a duty under this code has committed or is about to commit. I wanted to ask you how your office... Yes, Mr. Gessler? I wanted to ask you how your office has interpreted the committed or is about to commit language.
Your Honor, we would object this to testimony on the interpretation of the statute.
And I'm going to overrule it because I don't think she's testifying as to what it does, just how it's historically been interpreted by the Secretary of State. I'm the one that's going to have to decide what the actual effect of the statute is.
Do you need me to repeat the question, or do you remember it?
If you repeat it once.
I was asking how the Secretary of State's office has interpreted the language, has committed or is about to commit a breach or neglect of duty or other wrongful act.
In general, the office has interpreted this to mean that if the office has made a decision with which any of the parties listed in the statute disagrees with respect to conducting an election, that means they have the right to challenge that decision in court and receive a decision.
Okay. And in your experience, have people using 11113 to make challenges done so both before an act has been taken and after an act has been taken? So the about to commit language and the committed language?
I can't think of specific examples, but generally speaking, yes, I think leading to an election, that has happened.
Okay. Take you back to my question about what role the Secretary of State's office has in the administration of elections. You described a broad role, and are those duties and powers of the Secretary of State set forth in statute?
Yes, generally speaking, they're set forth in Section 1-1-107 of the Colorado Revised Statutes. There's also a provision in Article 1.5, which discusses the Secretary's authority specifically with respect to federal elections.
Okay. Now I'm going to turn to ask you some more questions about ballot access generally. You testified that that is one of the functions of the Colorado Secretary of State's office. So more specifically, what role does the Secretary of State's office play in candidate ballot access?
So our office is the filing office for state and federal offices for individuals seeking access to the ballot, seeking to run for office in Colorado. So we receive that paperwork, we verify the information on the application as required under state law, and then ultimately there's a deadline by which our office must certify all contests to the ballot, candidates and measures.
So specifically, what role does the Secretary of State play in certifying that content for the ballot?
Can you tell me what you mean by that?
So do candidates submit information to you that then you use to certify the content for the ballot?
Yes, so the law requires candidates submit specific paperwork depending on how they're accessing the ballot, whether that's by petition, through assembly, or whatever the nominating process is. And based on the legal requirements for that paperwork, then we will verify the information on the paperwork and then set the ballot.
And what is the deadline for the ballot certification for the presidential primary for Colorado in 2024?
I believe it's January 5th.
Is the process for ballot access, explain the process for ballot access for presidential candidates for the presidential primary in Colorado.
So for the presidential primary election, what the law requires is that candidates access the ballot through one of three methods. The first is through party nomination, so they would submit a candidate acceptance, a letter from the party saying they're a bona fide party candidate, and a filing fee. If they choose to submit a petition, they would submit their petition. Before they can circulate a petition, they need to submit the statement from the party that they're a bona fide party candidate, circulate a petition, and then with their petition submission, they would also need to submit the acceptance of nomination form for the petition. And then the third option is to submit a writing affidavit of intent and filing.
Has Colorado always had a presidential primary?
No.
Can you explain when we didn't have one and when we got one?
So Colorado had a presidential primary for several years until around 2000, and then it was eliminated in law. And then in 2016, a citizen initiative passed reestablishing the presidential primary and reestablishing with some specific processes around our current ballot.
And where in the law is the process for presidential primary candidates to be placed on the Colorado presidential primary ballot?
It's in Article 4, and I would call a specific statute citation.
Okay. I'm going to have a copy of that statute brought up just for demonstrative purposes, and that's statute, Colorado Revised Statute 1-4-1204. Do you see that statute there? And does that, just to be clear, does that statute apply to other ballot access candidates?
No, this is the statute specific for presidential primary elections.
Okay. Okay. So this part of the statute deals with how a candidate gets their name on the ballot, correct?
That's correct.
And you walked through the various processes in your testimony a moment ago. What is the Secretary of State's view of whether it may exclude candidates from the ballot who are constitutionally prohibited from assuming office?
It's the Secretary's position that if we have affirmative knowledge that a candidate is ineligible for office, then we will not certify them to the ballot.
Let's talk just a little bit about state legislative candidates and how the Colorado Constitution applies to them, and then we'll talk about the presidential candidates in the U.S. Constitution. What are the constitutional eligibility requirements for state legislative candidates?
Well, there's a residency requirement that a candidate reside within their district for the requisite amount of time. There's an age requirement, and then obviously the Colorado residency requirement. If it's a partisan office, which state legislative office is, then they must also be affiliated with the party nominating them or unaffiliated for the specific period of time.
And has the Secretary of State's office kept state legislative candidates off the ballot due to ineligibility in the past?
Yes.
About how many times?
I couldn't say with any certainty. I mean, it's not unusual for us to correspond with the candidate and ask for additional information to determine if they have additional information to prove an eligibility requirement like residency. But it has happened that a candidate doesn't reside within their district or hasn't been affiliated with the party for the right amount of time. And what process does the Secretary of State's office undertake to verify the qualifications for those state legislative candidates? When our office receives the candidate paperwork, we verify the information on that form with the information in the statewide voter registration system.
And if the Secretary of State's office determines that a state legislative candidate's records in the statewide voter registration database show that the person meets the eligibility criteria, what happens next?
Then they are qualified to the ballot and will be certified by the deadline for certification.
And what happens in that case if someone disagrees with the Secretary of State's decision on candidate eligibility?
In that case, if someone disagrees with that decision, then they can challenge that decision in court.
And is that the Colorado Revised Statute 11113 process we just discussed?
Generally speaking, yes.
Mr. Rudy, would you mind moving the microphone just a little bit closer to you? Thank you.
how frequently are those decisions of eligibility challenged? Like, how frequently is your office responding to those 11113 or other challenges of candidate eligibility?
I think generally in almost every election in which we're certifying candidates or measures to the ballot, we expect they may be challenged based on our decision to certify or not certify a candidate to the ballot.
So if your office determines that a candidate's records in the statewide voter registration database show that the person is not eligible because they don't reside in the district or they're not of the proper age or some other defect, what actions does the Secretary of State take?
Generally, especially in the case of presidency, we correspond with the candidate to see if they have additional information that establishes that they do meet the eligibility requirement in order to determine whether to qualify them or not qualify them to ballot.
So, and after you engage in the correspondence or dialogue, what happens if you are not satisfied after you've engaged in that dialogue that the candidate meets the qualifications?
I would say that if it's unclear in any way, we're going to escalate to the administration and seek guidance before we make a final decision. But in cases where it's very clear, we'll go ahead and exclude the candidate from the ballot.
And again, if someone disagrees with the Secretary of State's decision to keep a candidate off the ballot, what can they do?
They can challenge that decision in court.
And after a court proceeding, whether it's 11113 or another proceeding, what does the Secretary of State's office do if a court determines that a candidate is eligible?
Then we'll certify that candidate to the ballot.
And conversely, if someone disagrees with the Secretary of State's decision to put a candidate on the ballot, do they also have the same recourse to challenge that decision?
Yes.
And that's a similar proceeding in court?
It's similar, yes. Yeah.
And what does the Secretary of State do after a court proceeding if the court determines that a candidate is ineligible?
Then the Secretary would not certify the candidate to the ballot.
Has the Colorado Supreme Court provided guidance to the Secretary of State on candidate eligibility in terms of past decisions?
I think likely, yes, that's happened, but I can't recall specifically.
Okay. Are you familiar with Colorado Supreme Court decisions interpreting Colorado's ballot access laws?
Yes, generally.
And is it fair to say that they've weighed in many times on ballot access determinations?
Yes, generally speaking, I think typically we see that weighing in on citizen initiatives in particular.
Okay, let's turn to presidential candidates now. What is the process to verify the qualifications for presidential candidates?
Our office looks at the information provided in the affidavit itself, and if the affidavit is complete and we have no affirmative knowledge that any of the information is incorrect, then we would qualify that candidate to the ballot.
And
Is this the statement of intent, the affidavit you're referring to? Yes, Your Honor, the statement of intent.
how many times has the Secretary of State's office kept a presidential candidate off the ballot?
I don't have a specific number. It definitely has happened, and particularly for the general election.
And what does the Colorado Secretary of State's office do with a constitutionally ineligible candidate?
What do you mean?
Do you not certify them to the ballot in that case?
Yes, that's correct. If there's information that they are not constitutionally eligible.
Do you remember a ballot access case involving a Mr. Hassan?
Yes.
I'm going to pull up Exhibit P107. This exhibit has been stipulated, so I would move it into admission.
107 submitted.
Do you recognize this document?
Yes.
And what is this?
This is a letter that our office sent to Mr. Hassan after corresponding with him about access to the general election as an unaffiliated candidate for president.
And what year was this?
This was in 2011.
And how did it come about that Mr. Hassan was kept off the ballot?
Mr. Hassan began corresponding with our office seeking access as an unaffiliated candidate for president, but notified us that he was not going to fill out paperwork because he did not want to check the box that he was not a natural-born U.S. citizen. He didn't want to commit perjury, but he did want to seek access and was looking to set up lawsuits challenging that provision in the Constitution.
And what did the Secretary of State's office determine regarding Mr. Hassan's eligibility?
Mr. Hassan told us affirmatively that he failed to meet one of the constitutional qualifications. He also refused to file all of the required paperwork, and so our office advised Mr. Hassan that if he was in fact ineligible and did not file the required paperwork, that he could not be a candidate for office.
I'm going to direct your attention to the third paragraph in this letter.
Yes.
Could you read that first sentence for me?
The Secretary of State is responsible for ensuring that only eligible candidates are placed on the ballot and must give effect to applicable federal and state law unless the court has held such law to be invalid.
And is that still the position that the Secretary of State's office takes today in 2023?
It is.
And can you describe generally what that first sentence in that letter means?
Well, as I said, the Secretary's Office is responsible for certifying qualified candidates to the ballot and for overseeing the conduct of elections for those candidate races. And so our office is responsible for ensuring that we verify, to the extent the law requires us to, eligibility of candidates before placing their name on the ballot.
And based on that statement, can you confirm that the Secretary of State's office considers both federal and state qualifications when determining whether a candidate is eligible?
We do.
And what position does the Secretary of State's office take on whether it is the final arbiter of eligibility?
The Secretary's Office is never the final arbiter of eligibility because the Secretary's decision to either certify a candidate or not can be challenged in court.
And did Mr. Hassan take his case to court?
As I recall, he did.
And do you recall the outcome of that case?
Generally, the outcome of that case was the court affirmed his ineligibility.
His ineligibility, yeah. And so once the court affirmed his ineligibility, what did the Secretary of State's office do?
We did not place Mr. Hassan's name on the ballot for the 2012 presidential election.
Is the process you outlined for presidential candidates generally the same process for other federal candidates seeking ballot access for congressional or senatorial seats?
Generally speaking, it's the same. For congressional or senatorial seats, we're also required by law to verify residence, party affiliation for partisan candidates.
And aside from Mr. Hassan, have there been other federal candidates disqualified based on constitutional requirements? To your knowledge?
To my knowledge, I can't recall.
Let's walk through, you testified a few minutes ago about the general process for presidential primary candidate ballot access. I'm going to we're going to look at Exhibit P158, which has also been stipulated into evidence, and we'll look at page 2 of that exhibit. Do you see that document?
Yes.
And do you recognize it?
Yes.
What is it?
It's the major party candidate statement of intent for the presidential primary.
And I'd like to ask you some questions about the form itself first before we talk about the candidate who's filled it out. Who created this form?
Our ballot access team within the elections division.
And how long has this particular form been in use by the Secretary of State's office?
This form has been in use since the 2020 presidential primary paperwork deadlines. And this particular version of it since June.
And I see at the bottom, are you looking at the bottom right of the form?
Yes, that's correct.
And does it indicate there when it was last revised?
It does, although it's cut off on the screen, I see.
Oh, okay. Well, there you go. Can you see when it was last revised?
Yes.
When was it?
June of 2023.
And why are these forms revised?
Well, in this case, our office suite had changed, and so we needed to update the suite number to ensure we receive our mail properly. And we also had transitioned to a .gov domain since the 2020 elections. We needed to update the email address, and we updated the year at the top of the form.
And were those the only changes to the form, to your knowledge?
To my knowledge, yes.
And so this is the aside from the email address and the suite number, this was the same major party candidate statement of intent for presidential primary that was used in the 2020 cycle?
Yes.
At the top of the form, let me ask you a general question about forms. What role does the Secretary of State's office play in creating forms that are used by candidates for ballot access?
The Secretary's office creates all forms that are used for candidates for state and federal office for ballot access.
All right, turning back to the form itself. At the top of the form, do you see where it says office information?
Yes.
And what is the significance of that language?
Well, generally at the top of each of our ballot access forms, we include information about the office being sought so that the candidate is aware they're completing the correct paperwork, but also for our staff in terms of processing that paperwork and verifying qualifications.
And so underneath that office information, it says year of presidential primary election 2024. You see that?
Yes.
So presumably that year was also changed on this form, right?
Yes, that's correct.
And then it lists the political party for the candidate.
Yes, that's correct.
And then there's a section for qualifications for office. You see that?
I do.
And what are the qualifications listed here?
The qualifications listed here are age 35 years, resident of the United States for at least 14 years, and natural born U.S. citizen.
And do you know where those qualifications came from?
From the U.S. Constitution.
And are you aware there are other qualifications for the president that are contained in the U.S. Constitution?
Yes.
I'm going to turn your attention to about halfway down the form. There's it might not be blue in yours, it's blue in mine. There's a bolded word that says signature. And underneath that, it says applicant's affirmation. Can you read that affirmation?
I intend to run for the office stated above and solemnly affirm that I meet all qualifications for the office prescribed by law. Furthermore, the information provided on this form is, to the best of my knowledge, true and correct.
And how does a candidate submitting the form confirm that affirmation?
A candidate would sign that affirmation and have that signature notarized.
And how does the Secretary of State's office view that affirmation when considering a candidate's qualifications?
Can you tell me what you mean by that?
Well, that affirmation states that the person meets all qualifications for office. So does the Secretary of State's office interpret that to mean more qualifications that are listed on the form?
Well, qualifications listed on the form aren't intended to be an exhaustive list of qualifications, but we do require that every candidate affirm that they meet every qualification for office, regardless of what's listed on the form.
So is it fair to say that that affirmation is like a catch-all affirmation?
I'd say that's fair, yes.
And do you have similar catch-all affirmations for other non-presidential candidates on their candidate statement of intent?
Every candidate would sign an affirmation that they meet all qualifications for the office they're seeking.
If a candidate checks the boxes on the form under qualifications for office and signs the affirmation, what, if any, additional inquiry does the Secretary of State make?
Our office isn't going to further investigate that affidavit. It's on its face complete and accurate, and so based on that would certify candidate to office, or I'm sorry, to the ballot.
And as you testified a moment ago, a Colorado voter could challenge that determination of the Secretary of State, correct?
Yes, that's correct.
Are you familiar with the 22nd Amendment to the United States Constitution?
I mean, generally, I haven't read it recently.
Well, can you state generally what your knowledge of it is?
It would be helpful to see it.
Yeah. Well, I'll just represent it to you, because generally what it says is the president can't hold more than 2 terms as president. Do you have any questions, or do you accept my description of the 22nd Amendment? Has the Secretary of State ever received a statement of intent for a presidential candidate who has already served 2 terms as president?
Not to my knowledge.
From, say, Barack Obama or George W. Bush?
No, not to my knowledge.
And what would the Secretary of State's office do in that situation?
Well, I think that knowing that both of the potential candidates you named have so served both terms, I think that the ballot access team would escalate that within the office to the administration for additional guidance, but likely we would not certify that candidate to the ballot.
When you say elevate to the administration, give me just a little description of what that means.
Sure. So when the ballot access manager or ballot access team receives paperwork and there are questions about whether an eligibility provision is met and it's not clear, we will escalate that through our legal team within the elections division to the Deputy Secretary of State for additional guidance.
Okay. You testified a few moments ago about how sometimes if there are eligibility questions, you engage in dialogue with the candidate. Would you engage in dialogue with George W. Bush or Barack Obama on that point?
I think we'd seek some guidance from the Deputy Secretary before corresponding.
Okay. All right, let me ask you some specific questions about the pieces of this form that were filled out by the candidate. Who submitted this particular form?
Donald Trump.
And when did the Secretary of State's office receive this form?
If we could scroll to the top.
Oh, sorry. There you go.
We received it on October 11th, 2020.
And turning to the applicant's affirmation down at the middle of the page, who signed the form?
It appears to be Donald Trump.
And what, is the signature properly notarized there?
It is.
In your reading of this form, has the candidate verified the applicant's affirmation? At the middle of the page there, that affirmation that you read.
Yes.
And what did your office do when you received this form?
Our office, the ballot access team escalated the question to the Deputy Secretary because there's ongoing litigation with respect to this applicant's qualifications.
And so has your office taken any action with regard to certifying this candidate to the ballot or not?
We have not. We're not at the certification deadline, and it is our practice that when there is an ongoing legal challenge to our office's determination about a candidate's qualification, that we wait for that outcome.
Okay, let's turn to page 3 of that exhibit. Which is the next page. There we go. Do you recognize this document?
Yes.
And what is this?
This is the state party presidential primary approval form.
And what's the purpose of this form?
The purpose of this form is for the state party to advise our office that the candidate seeking party nomination is a bona fide party candidate.
And who created this form?
Ballot access team within the election division.
And how long has this form been in use by the Colorado Secretary of State?
Since 2020.
And was it similarly revised this year?
Yes, we would have revised the suite number and the email domain as well on this form. And the date.
And at the top where it says party contact information, what is shown there?
That's the contact information for both of Colorado's major political parties.
And so that contact information may also have been changed since 2020, correct?
Yes, that's correct.
Has the same form been used by the Secretary of State's office regardless of the political party of the Secretary of State?
Yes, this form has only been used, this will be the second presidential primary in use.
Okay. And the last presidential primary, who was the Secretary of State?
Wayne Williams?
Just to confirm, who has the authority to revise or edit this form?
The ballot access team within the elections division.
Okay, now let's talk about the content of this form in terms of who filled it out. One moment here. I'm going to just ask you a clarifying question on the presidential primary in 2020. Who was the Secretary of State then?
Jenna Griswold, Secretary in 2020.
Okay, who submitted this form that you see on your screen?
Donald Trump.
If you look at the bottom of the, well, let me ask you about that. Why do you say Donald Trump submitted this form?
That's the candidate listed.
And so the information on the bottom of the form is, what is the information at the bottom of the form?
It appears it was submitted by the campaign representative from Mr. Trump and signed by the state party chair.
And so does the candidate actually submit this form as well?
It's submitted by the candidate's campaign typically.
Okay, but not submitted by the state party?
No.
Okay. And at the, if we look at the bottom half of the page, it says state party use only. Do you see that?
Yes.
And can you tell us who is the party official that submitted this form?
Dave Williams,
And what is his official job title?
chair of the state party.
I asked that because that was not a trick question, and maybe you can't see it, but it does say that on the bottom of the form, so well done.
It's cut off on the answering.
Okay. Has this particular form been modified by any of the persons filling it out from its original template?
It doesn't have a template.
Okay. And what did your office do when you received this form?
We placed this with the other candidate paperwork for this candidate.
What happens if a candidate doesn't submit this form?
Then we communicate with the candidate that this form is required before we can certify them to the ballot for the presidential primary.
And you testified a few minutes ago about that the state party has to approve that the candidate is a bona fide candidate. Do you remember that testimony?
Yes.
What does it mean to be a bona fide candidate?
I don't know what that means to the party. From our perspective, it means that the party approves that that candidate represents the party.
What position is the Secretary of State's office taking in this litigation?
It is the Secretary of State's office position that the paperwork is complete and final, but there is a challenge to this candidate's qualification, and so our office will not certify this candidate valid until the court makes its decision.
And if this proceeding ultimately results in a determination that Mr. Trump is eligible to be a candidate for the Colorado presidential primary, what will the Secretary of State's office do?
The Secretary's office will certify the candidate.
And similarly, if the outcome of this litigation is that the case is dismissed without further guidance from the court, what will the Secretary of State's office do?
I can't speculate as to that. I think we need to wait for the court's outcome before we make a decision.
Ms. Rudy, are you aware of any threats that the Secretary of State's office has received regarding election activity?
Your Honor, I won't object to this. It will be on the scope of what we were notified as the testimony, and it's frankly irrelevant to this case.
Well, the Secretary of State's office, I think, has a lot of knowledge about threats to election officials in the state, and I think the relevance here is that those threats can be tied, and I will try to tie them to some of the January 6th activity.
I'm going to sustain the objection. It's outside the scope of this hearing.
As a housekeeping matter, Your Honor, I want to move to admit P158, which is the document on the screen, which was stipulated into evidence. I just didn't move it.
I'm sorry, what was the number?
P158.
Instead of 158 submitted.
May I have just one moment? No further questions, Your Honor.
Morning, Ms. Rudy.
Morning.
How are you today?
Good.
Good. So I'm going to ask you a few questions. I believe I have cross-examined you at least a few times in the past 2 decades or so. So I'll just, if you don't understand a question that I have, please just ask me.
I'm just going to give the microphone, Mr. Gissler.
Certainly. If you don't understand a question I have, just please ask me to repeat it. Let me start with, in preparation today, so you did not speak to any members of the petitioner's attorney, correct?
That's correct.
Okay. Did you speak about your testimony with anyone in the Secretary of State's office?
I did.
And who was that?
Deputy Secretary Beal.
And tell me what your conversation was with him.
In what respect?
Describe the conversation. What topics did you discuss?
We generally discuss the topics that I would expect to speak about today, and
Okay. Did you talk to him about the Secretary's position or lack thereof of a position with respect to this litigation?
we discussed this litigation, and we discussed my testimony today, yes.
Okay. And as part of that discussion, did you have a discussion with him as to what position you would describe with respect to the litigation?
What do you mean by what position?
Well, you testified earlier that the Secretary is going to wait for the court's outcome. And you also testified as to the meaning of the form. Did you discuss either of those two issues with Deputy Secretary Beal?
I generally shared with him what my answers to those questions were, yes.
And when you gave your thoughts as to what those answers were, did he tell you what perhaps his position was, or his thoughts on that, or what the Secretary's thoughts were?
Apart from saying that he agreed with the position I was stating, no.
Okay. Did you have any conversations with the Secretary herself on this issue?
I did not.
Okay. Did you have any conversations with the Director of Elections, Judge Shelwood?
I did not talk with Judge Shelwood, yes.
Okay. Okay. Did Mr. Beal inform you as to what the topics were going to be for your testimony today?
Yes, Mr. Beal and counsel.
Okay. And did he walk through, did you provide all of your answers that you anticipated giving today? Did you provide those answers to Mr. Beal as well?
Yes.
Okay. Did he ask you to change your opinion in any way?
He did not.
Okay. Okay, let me ask you, you had testified a little bit earlier about the 3 methods for a major party presidential candidate to get on the ballot. Do you remember that?
Yes, any presidential primary.
Okay. And you said to get on the ballot for a presidential primary, there was the party nomination process, the petition process, and then the affidavit plus fee process, correct?
That's correct.
So I will tell you, my read, I didn't quite understand what do you mean by the party nomination process?
That's the process of filing the candidate affidavit, the party form of bona fide party candidate, and the application fee.
Okay. How does that differ from the filing of the affidavit of intent and the fee?
The third affidavit of intent and the fee is for a write-in candidate.
Okay, for a write-in candidate for the party nomination.
That's right.
Okay. Let me ask you this. So, and I was just wondering, so the form, and we may bring it up, but the form that, the statement of intent form, that was created in 2020, correct?
That's correct.
Okay.
Well, 2019, ahead of the 2020.
In preparation. Was there any rule or regulation setting the contents of that form?
No.
Okay. And you said earlier that the ballot access team has authority to modify that form.
That's
correct.
correct.
Did the ballot access team create that form?
They did.
Okay. And did they have full authority to create that form?
They did.
Okay. And so that form is essentially created by the ballot access team, correct?
Yes, that's correct.
Okay. And I want to chat with you about the qualifications too. So there's I want to chat with you about the congressional form. Are you familiar with the fact that the congressional form also requires a person to check 3 boxes for eligibility?
I've not recently looked at the congressional form. If I could see an example of it, that would be helpful.
Because I'm afraid of the technology, I'm going to see if I can describe this to you. I'm going to represent to you that one of the boxes that the candidate checks says inhabitant of state. Does that refresh your memory, or do you still need to see the form?
It would be helpful if I could see the form.
Fair enough. Your Honor, can we take about a minute break? I'd like to just pull up that form, please.
Sure. While your team is finding that form, can you...
Just continue the Sure.
We'll do another topic and then come back.
Okay. Just let me. Are you able to keep that form? Can you get that form? Okay. All right. Oh, we have it. All right. Do you see that form in front of you, Ms. Rudy?
Yes.
Okay. And that.
This is the write-in form.
This will work. I want you to take a look at the write-in form. That works fine. And the second box says inhabitant of Colorado, correct?
The second box under qualifications for office says that, yes.
Okay. And in order to, does that mean that the person has to be an inhabitant of Colorado at the time they fill out that form?
We verify that they are at the time they fill out that form, yes.
That they are an inhabitant of Colorado at that time?
Yes.
Okay. And is that the, would you agree with me then that that's the office's interpretation of federal requirements to qualify for the ballot, that they have to be an inhabitant of Colorado?
I don't think that's the sole qualification for that office.
I understand, but it's the office's interpretation that that's one of 3 required qualifications for them to be on the ballot. Is that correct?
Yes.
Okay. And would it be fair to say then for the presidential candidate form, it's the office's interpretation that to qualify the candidate has to fill out the 3 requirements, specifically that they're a natural-born citizen, 14-year resident, and 35 years of age?
Yes, the form must be fully completed, each of the boxes checked, and the affidavit affirming that they meet all qualifications for office must be signed and list.
Okay. And the statutory basis for those 3 requirements is there a statutory basis for those 3 requirements in Colorado law that you can point to?
Are we talking about the presidential form?
Presidential form.
Yes, there's a statute that tells us that we give effect to the federal qualifications for office.
Okay. And is that the same statute that you rely on for this, the qualifications for this write-in form?
If you could bring the statute back up again, please.
You had said there was a federal statute. I'm sorry, there was a state statute. Can you tell me what state statute that is?
I don't recall the specific citation, but all of the qualifications and requirements for the presidential primary are contained within Part 12. I'm sorry, within Part 12 of Article 4.
Okay.
1-4-1201.
Okay. So it's the 1-4-12, the 1201, the 12 series of statutes that set forth the statutory basis for those requirements.
That's correct.
Okay. And then for these 3 requirements for the write-in candidate, I'm going to, for the United States representative candidate, where it says at least, I think that says 25 years old, inhabitant of Colorado. And then the third item, is there Colorado statute that requires you to requires the office to include those 3 as well?
I don't recall off the top of my head, but the provisions for becoming a candidate in Colorado for Congress or Senate are set up in a different area of the law.
Okay. Is it the office's practice that you need a state statute to include those 3, or you can just, or you look only to the U.S. Constitution?
The office is required to certify eligible candidates to, and so wherever those eligibility requirements are set out is where we look.
Okay. And so that's the office's attempt, that's the office's approach in establishing what the qualifications are for a candidate, creating that form with those 3 boxes.
Again, that's not intended to be an exhaustive list of qualifications for office, but yes, we list the primary qualifications for office, and then each candidate signs an affidavit that they meet every qualification for office.
Okay. So there could be more qualifications for this affidavit of intent for a write-in designation that are not on this form.
There could be.
Okay. And you're saying that's the intent, and it has been the intent of the office since you've been there?
Yes.
Okay. And the basis for saying that that's the intent is the affidavit write-in. What's the evidence that you're relying upon to say it's the intent? Is it your memory, or are you able to point to something else?
I've worked in the office for 17 years, and that's been the practice since I have worked there.
Okay. The practice has been for the form to not necessarily include the form itself, to not necessarily list all of the requirements for an office holder. Is that correct?
That's correct. In the past, the form required the candidate to list their qualifications for office. The inclusion of checkboxes was intended to help candidates out to identify their specific qualifications.
Okay. Can you identify any other forms in the office that have requirements, but that do not list all of the requirements on the form itself?
As I sit here now, no. Our office produces quite a number of forms.
Okay. And you produce those forms to be able to provide guidance for a candidate, correct?
We produce those forms to provide guidance for candidates, campaigns, parties, voters. Our office produces quite a number of forms.
Do you produce those forms to be binding legal authority as well?
I'm sorry, what do you mean by that?
Do you produce those forms to be binding legal requirements for candidates as well? So is the information required to be filled out required for candidates under law?
In order to gain ballot access in Colorado, a candidate must complete fully their paperwork before they submit it.
Okay. Let's talk about going behind paperwork. So you're familiar with the controversies involving the natural-born citizenship for President Barack Obama when he ran in 2012. Is that correct?
I read the news.
Okay. Did that rise to the level for the office to investigate whether President Barack Obama was in fact a natural-born citizen?
Our office never received any formal complaints or requests to consider that information.
Okay. So that wasn't quite my question. You earlier said that if you have affirmative knowledge that a candidate does not meet certain requirements, you'll keep that candidate off the ballot, correct?
Correct.
Okay. And so if someone comes to you and says, I have evidence that this candidate is not 35 years old, will you keep that candidate off the ballot?
We would escalate that to the Deputy Secretary for guidance.
Okay. And do you know what the criteria are that the Deputy Secretary of State would follow for that guidance?
If we have affirmative information that a candidate is ineligible, it is the office's view that the Secretary can refrain from putting a candidate on the ballot.
Okay. So if someone were to come up and say, I have affirmative evidence, here's evidence that this particular candidate is not 35 years old, what do you do with that evidence?
I can't speculate as to a hypothetical, not knowing what that evidence is. That would have to be the discussion with the Deputy Secretary.
Okay. And then the Deputy Secretary would make that decision as to the quality of the evidence?
The Deputy Secretary, the Secretary would advise the division as to the best manner to proceed.
Okay. And the division would follow that advice, correct?
That's correct.
Okay. So the Deputy Secretary of State or Secretary would instruct the division on how to proceed, correct?
That's correct.
Okay. And so the Secretary and Deputy Secretary themselves would sort of personally would evaluate the quality of the information that you received, correct?
The ballot access team would seek that guidance from the Deputy Secretary. That's correct.
Okay. And do you know whether or not the Deputy Secretary of State and the Secretary of State would then evaluate the quality of that information? I'm going to ask you to hold off for a second because we have sirens. It's been the pattern of practice in this courtroom. Do you need me to repeat my question?
Please.
Okay. So do you know the criteria that the Secretary and the Deputy Secretary of State would use to evaluate the quality of that information?
Again, I can't speak to a hypothetical situation.
I'm not asking you to speak to a hypothetical situation. I'm asking if you know what criteria they use to evaluate that information.
Since we're not in a situation where we're applying those criteria, I can't speak to what criteria they use.
Okay. Now let's go back to the that write-in candidate form, please. Okay. So if I fill out, let's say I decide to have a temporary bout of insanity, and I decide to run for U.S. Congress as a write-in candidate, and I fill out the form, and I say I'm not an inhabitant of Colorado, but I will become an inhabitant at the time I'm elected. Would you allow me to run? Would the office allow me to run for office?
We would escalate that to the Deputy Secretary to have a discussion.
Okay. I'm going to represent to you that the U.S. Constitution explicitly requires a member of Congress as a qualification to hold office at the time they are elected. With that information, does that change your answer?
Again, I can't speak to hypotheticals. We would escalate that for a discussion with the Deputy Secretary before making a decision.
Okay. And it's the Secretary or the Deputy Secretary that would make that decision?
We would seek their guidance before making a final determination, yes.
Okay. For Hassan, if I remember correctly, you testified that Hassan never submitted the paperwork, the statement of intent, correct?
Yes, that's my recollection.
And that was a statement of intent for a write-in candidate, correct?
I don't recall specifically. Would it be possible to pull the letter back up?
Sure. I will represent to you that he was for a write-in candidate. Will you accept that representation, or would you like to take a look at the letter?
I mean, I prefer to take a look.
That's fine.
This afternoon.
Could we pull that letter up, please? I think, Mark, was that key 158?
107.
Key 107. Just tell us if we need to scroll down.
Yes, could you scroll to the second paragraph, please? I don't see that it's for a write-in candidate. Honestly, I don't recall.
Okay. Do you recall him being an unaffiliated candidate?
Yes, he was an unaffiliated candidate for the presidential election in November of 2012.
Okay. And he refused to submit the paperwork, correct?
That's correct.
Okay. So that did not, as a result, you did not actually have to evaluate the paperwork because it was never submitted to your office, correct?
We did not have to evaluate the paperwork, but we corresponded with him with respect to his qualifications.
Okay. No further questions, Your Honor.
Do you have some questions? Okay.
Good morning, Ms. Rudy. I'm Jane Raskin. I represent the Colorado Republican Party. I just want to go back and make sure I understand the procedure you described your office is following when it, in connection with a presidential primary election, it receives paperwork under what I think you described as the party nomination process, right? So in that instance, as I understand it, you typically will receive the major party candidate statement, the one you went over earlier. I think it was Exhibit 158. And that contains, as an attachment, as I understand it, a document that's called the State Party Presidential Primary Approval.
We received 4 presidential primaries for major party candidates, the candidate statement of intent, the party approval form stating the candidate is a bona fide party candidate, and the filing fee.
Okay, so you now have those 2 documents in hand, say. What do you do, and those forms, as you have described, contain an affirmation by the candidate that he satisfies the requirements of law for the office he's seeking access to the ballot for, right?
Yes.
And they include specifically 3 boxes for the candidate to check, to which he affirms that he's 35 years old and a natural-born citizen, and he's lived in the country for 14 years, right?
That's correct.
So you get that document, and you get the companion document, which is the party's certification that he's a bona fide candidate of the party. What do you do to verify the candidate's affirmation that he is in fact qualified to hold the office for which he's seeking access to the ballot?
The ballot access team doesn't do any investigation beyond the review of the paperwork to ensure it's accurate and complete, and to review the party paperwork to ensure that the approved box as opposed to the disapproved box is checked.
And if those boxes are all checked, the paperwork is in order, you certify that candidate for inclusion on the ballot, correct?
Well, it depends on where we are in the timeline. We don't certify candidates to the ballot until January 5th.
Okay, so you may get the paperwork early, but you wait till shortly before the certification date to actually complete the certification.
We certify on the certification date.
Okay. And I assume that is in part to allow time for other interested parties to challenge the form, if they want to, as you've described.
What is in time? I'm sorry.
So during the period of time after which you've received the major candidate statement and the party's certification that the candidate's bona fide candidate of the party, you've said that other people, whether it's a competing candidate or another party or another elector, can come in and make a complaint, either informally, say, hey, look, I think this guy, wasn't born in the United States, or alternatively can actually file a petition under 113, right?
That's correct.
So before you certify the ballot, you have this time period where those issues may be raised and may be resolved.
Those issues may be raised, but there are also other deadlines within that time period before certification for petitions and for the affidavit for writing. Those deadlines come a little bit later.
No, I understand, but I'm just talking at this point about the process for a candidate nominated by a major party.
I understand, but you asked why we wouldn't certify until the deadline.
So in other words, what you're saying is you certify all of the candidates the same day.
That's correct.
So the others may implicate that decision even if you already have the major party candidate? Is that the point you're making?
All major parties may be certified for the presidential primary ballot, but there are multiple ways to be placed on the ballot, and those deadlines differ. So we certify all candidates for both major party presidential primaries on the same date.
Okay. So let's go back to the point at which you receive the paperwork. And understanding you don't certify it until the deadline. If nobody comes in with any, what you've described, I think, is affirmative information that there's something incorrect in the certification form, and no one has filed a 113, and you ultimately reach the certification date, it's the Secretary's duty to certify that candidate to the ballot, correct?
That's correct.
Okay. So when you were discussing earlier that when you got some forms and you verify the info is required by state law, you were talking about candidates for state office, right?
We review every form that our office receives. State law requires us to verify information for state candidate forms and for presidential primary elections. We review the information on the affidavit itself. We're also required to verify that the party has completed the party approval form and has approved the candidate as a party representative.
Right, but for federal candidates as opposed to state candidates, you don't have an equivalent process to check any databases to determine residency or where the person was born or things of that nature, as you do with state candidates.
For presidential candidates, that's correct.
Okay. So when you testified earlier that, I think what you said was that the Secretary is never the final arbiter of whether a candidate is eligible to be listed on a ballot. That's not the case if there is no challenge made to the request to be included, correct?
There's always an opportunity for the Secretary's determination to be challenged in court, and in that case, the court is the final arbiter.
Sure, there's an opportunity, but if nobody places a challenge, nobody complains, nobody files a 113, then the final decision is made by the secretary.
That's correct.
Okay. Just one more question. Has your office, to your knowledge, ever refused to certify a candidate for inclusion on the presidential primary ballot, understanding that it's been an issue for a short period of time?
Well, there are candidates that we've corresponded with, ahead of the 2020 election who failed to complete the paperwork. We've corresponded with a candidate ahead of this primary election, and they've failed to complete the proper paperwork.
Has there ever been an instance in which a candidate has completed the paperwork that your office has created that you have disqualified in a presidential primary election?
Not to my knowledge.
That's it. Thank you very much.
Thank you, Your Honor. Just a couple areas I wanted to follow up on, Ms. Rudy. You testified about Section 113 on your direct, you recall?
I do.
And you were asked some questions about when the official charged with the duty has committed or is about to commit a breach or neglect of duty or other wrongful act. Do you recall those questions?
Yes.
And you were asked specifically about when it might arise when a 113 would be brought before an election official, including possibly the secretary, has committed a breach or neglect of duty. Do you recall that?
Yes.
In the context of certifying a ballot on a certified before an election official exercises their duty to certify ballot contents, or whether the challenge will come afterwards?
There are a lot of provisions in the candidate statutes that allow a challenge to a candidate's qualification. If that candidate, for example, goes on a petition, there are very specific provisions that allow challenges to the secretary's determination. So typically those challenges arise under the statute that the candidate has followed to achieve ballot access.
And are sometimes challenges brought to whether a candidate will be listed on a ballot prior to a ballot certification deadline?
Yes.
And those challenges be brought under, or have those challenges been brought under Section 113?
Yes, I believe some have.
You've also been asked some questions about instances where the Secretary of State's office has not certified a candidate to be presidential candidate specifically. Do you recall 2012 primary ballots at the general election? Do you remember a candidate last name Wilson?
Yes, General.
Do you recall a dispute around Mr. Wilson and whether he would be placed on the presidential ballot as an affiliated presidential candidate?
Yes, as I recall, Mr. Wilson failed to complete part of the paperwork properly, and we communicated with him and ultimately chose not to place him on the ballot based on his failure to fully complete the paperwork.
Okay, and what about in 2016, which again is the general election, not for the primary, a candidate by the name of Denmore?
Yes.
Could you tell the court what you remember about that situation?
Similar to Wilson, Denmore, as I recall, did not fully complete the paperwork even after our office corresponded with them, and we did not certify them to the ballot.
And I believe you just testified a few moments ago about an instance that occurred in this election cycle for presidential primary ballot. Could you describe a little more of the circumstances around that?
Yeah, we received candidate paperwork for Joseph Maldonado, and the paperwork was not on the correct form. We hadn't updated and published the form yet. It wasn't properly notarized. It wasn't signed by the candidate himself. And so we returned the filing fee to that person and advised them that in order to seek access to the ballot, they needed to complete the proper paperwork, and that included the party approval paperwork as well.
Okay. Your Honor, that was it for my questioning. I know the court has some areas designated that I wanted to hear from a representative of the Secretary of State's office on. This is the only vote called witness any party is listed in the Secretary of State's office, so I wanted to be sure that the court had the opportunity to ask some questions.
Why don't we finish your direct and if no questions and address them?
Thank you.
I'm going to have one or two follow-up questions. I think we respectfully may have gone out of order based on posture parts, but if I can stay on after Mr. Chairman is done.
Why don't you do yours so that you can wrap up with a redirect?
Ms. Rudy, just very quickly, Mr. Wilson, Denmore, and Maldonado, all of those were rejected based on their failure to complete proper paperwork. Is that right?
Yes, that's correct.
In your experience, has there ever been a presidential candidate who has completed proper paperwork yet been kept off the ballot by your office?
As I said here today, I can't think of a specific example now.
Okay, thank you.
Ms. Rudy, you answered some questions from Mr. Gesser about the forms in the office. I just want to follow up on that briefly. He asked you who generally drafts the forms, and then you said ballot access team. Those forms are then reviewed by somebody else in your office for compliance with the law, correct?
Our legal team may take a look at the forms if there are substantive legal changes to those forms, so if qualifications have changed, or if it's the first instance of a form, but if we're updating addresses, things like that, it will just be file accessing.
But the first time a form is created or substantive changes are made, there's a further review of the form beyond the file access team.
Yes, that's correct.
Also, I just want to follow up on the confirming that your office, as you testified on direct examination, follows both state and federal law when determining candidate eligibility?
Yes, that's correct.
And even if the federal qualifications may not be spelled out elsewhere in state statute, correct?
Yes, that's correct.
And on direct examination, we also had a colloquy about the 22nd Amendment and what your office would do if George W. Bush or Barack Obama submitted a statement of intent. And you testified at that time that you would escalate that. What, and Ms. Dressler, I think, asked you some questions about what escalating means. In that situation, when you would escalate that question, if it were to be determined by the office that the George W. Bush or Barack Obama was ineligible based on federal constitutional qualifications, would you keep them off ballot?
If that was the determination, yes.
And conversely, if for some reason somebody kept them off ballot and somebody challenged that eligibility or the Secretary's determination to keep them off the ballot, and a court decided that they should be placed on the ballot, what would your office do?
We would certify them in the ballot.
I don't know.
So, Ms. Rudy, if you don't know the answer to this, it's totally fine, but what would you do if, well, first of all, is it your understanding that if the Secretary of State's office, the ballot access team all the way up to the Secretary of State, wanted to add a checkbox to address the 22nd Amendment, so it said, you know, you haven't been president more than 2 terms, would that be within, is your understanding something that the Secretary of State's office could do?
Yes.
And then another question is similar. If Barack Obama were to, President Clinton were to submit a statement of intent and check boxes are on there, regardless of what they are, and sign it, and nobody filed a lawsuit. In your estimation, what would the process be, given that presumably whoever's reviewing that would know that President Clinton already been president twice?
Again, it's hard to speak on articles, but certainly the ballot access team would escalate that through the legal team to the Deputy Secretary for guidance. But given that that was an objective noble fact, it's unlikely that we would certify that candidate on the ballot.
Anybody have any follow-up questions tonight?
Mr. Reyes, I want to ask you a question. So, the court asked you a question, and you said, with respect to the term limit, you said it's an objective, noble fact. You feel comfortable, or you predict that it's unlikely that the office would not allow that person to return a ballot. Is that correct?
In the situation that we discussed, yes, that's correct.
And because the 2 term limits, that's an objective, noble fact, correct?
Yes, we know that they've served 2 terms.
Right. Do you know this case is about 14th Amendment, correct?
That's correct.
And to your understanding that Congress can remove any disability to holding office under the 14th Amendment?
I understand that.
Okay. And would you agree with me that sitting here today, even if a court, whether in Colorado or elsewhere, were to hold that President Trump was disqualified, even in that highly likely situation, would you agree with me that it is not an objective, noble fact as to whether or not Congress will in the future remove that disability?
Yes, Your Honor. I don't think it was quite for that.
I'll let her testify to the extent she knows the answer, but she's not designated as an expert on the subject.
I really can't speak to how our office would handle that situation.
Well, let me ask you this. Would you agree with me that it's not an objective, noble fact, sitting here today, how Congress will react in any way between now and the presidential election in 2024?
I would say that, as with any area of law, it's impossible to know how legislative body will act looking into the future. I can't speak to how they will behave.
Thank you very much.
Does anybody else have any follow-ups?
Not the second one.
Okay, great. Thank you so much for your testimony, Ms. Rudy. Am I correct in understanding that Ms. Rudy was the petitioner's last witness?
Your Honor. We have one witness who is testifying out of order on Friday, that's Mr. Keefe. And also have some exhibits that we are reworking to submit, the January 6 findings in particular, so that we are submitting only those Your Honor has found to be admissible. Clean up the record a little bit. Highlight additional documents that are already admitted that we could not submit. But other than those three items, Mr. Keefe, January 6 findings, and some additional highlighting, we are
Okay. So, Professor, do we have anything we need to discuss before we call the first witness?
Yes, Your Honor, we'd like to move for directed verdict. We understand that Mr. Keefe is going to be testifying on Friday, but it's our understanding that he's testifying in requested support, specifically the disability of the January 6 report. And for purposes of our motion for directed verdict, we will assume that the January 6 report is fully admissible. So we would like to move for directed verdict. We have the opportunity to make that case done.
Okay, are you prepared to do it right now?
I am indeed.
Okay.
Thank you, Your Honor. We move for directed verdict and we're moving on very focused grounds, specifically with respect to the whether or not President Trump incited anything on granted birth standards under the First Amendment. And so basically, for purposes of this, we're accepting everything that the petitioner has provided in evidence, as well as we're accepting for obviously limited purposes the admissibility of the January 6 report. I just want to walk through the evidence that we received, apply what are very straightforward and well-established legal standards. We believe this case warrants dismissal at this point, because petitioners have not made out their case on this issue. So, as the court knows, there have been a number of arguments raised with respect to Section 113.12.4. This directed motion is not involving them. There have been a number of arguments presented with respect to the interpretation of Article 3. The 14th Amendment. This directed motion is not focused on that. What it is focused on is the Brandenburg standards, the definition of incitement. Our argument under Section 3 is that President Trump has to engage in insurrection. Petitioners have argued that incitement can constitute engagement. Although for overall purposes, we don't accept that argument, disagree with that argument. For purposes of the directed motion, we will operate on that premise. So, the evidence the courts received so far, and in totality, has been the January 6th report, or portions of the January 6th report. It received evidence from Officer Hodges, and he testified to activities, the violence and things that happened at the Capitol. He did not testify to President Trump's actions. Representative Pullo, he testified to activities that happened at the Capitol as well, from his perspective. He did not testify to President Trump's activities, beyond the Hindenburg speech. And Representative Pullo, of course, testified to things in prior years. Mr. Pinjon testified, again, very similar to Officer Hodges' activities at the Capitol. You have Professor Banks, who testified as to what President Trump's authorities were to mobilize National Guard on January 6th. He did not testify to President Trump's actions at all. You have Professor Magliocca, who testified as to the meaning of Section 3. He did not testify to President Trump's actions. And importantly, he did not testify as to the meaning of intent or the applicability of the 14th Amendment. So his testimony for purposes of this motion is not relevant. And then you heard from Hilary Rudy, who testified as the Secretary of State's authority, of course, much different from President Trump's actions. So basically, there's two things. One is information from the January 6th report, and the second is Professor Cindy's testimony with respect to far-right-wing extremists. Neither one of those shows that President Trump, in any manner, in any way, incited insurrection, incited violence, incited a riot. Not at all, under the well-established Supreme Court standards Brandenburg versus Hill. This case is entirely, petitioner's case is entirely a case about President Trump's speeches. His speech, his Twitter video. That's the entire body of their evidence. And that's the entire body of evidence from the January 6th report. They don't allege that President Trump was, had meetings with Proud Boys or Church Centers. They don't allege that he, carried a knife or a rifle or a march that had a column towards the Capitol. They don't argue that he engaged in any of those physical overt actions. It is all speech. That's the entire body of their case. And if you remember, the petitioner sort of had his chart up here, towards the end of Professor Simi's testimony, and he talked about this speech and that speech. Oh, there it is, over the corner there. All that stuff that President Trump did. And then, of course, they sort of have a pejorative memory aid, the punch in the face of why he's not going to stand back and say why. But those are all things that President Trump said. Every one of them is about him saying something, or not saying something. He didn't condemn activities in Georgia, Charlottesville. He didn't say something. So it's all speech. We submitted the speech standards under Brandenburg versus Ohio. I'm going to talk briefly, I don't want to be too pedantic, but I'm going to talk briefly about some of the applicability, okay? And particularly Professor Simi's testimony. So Professor Simi was very clear. He testified that he was not opining about President Trump's intent. He said, I'm not in President Trump's head on what his intent is. He said, what I can say is that I think his behavior is characteristic of communications with right-wing extremists. And he was very clear that President Trump's speech was interpreted in a particular way by these right-wing extremists. And as you remember, I questioned him, and we had all these sort of flight mysteries from political figures other than President Trump. And I asked him, were those students' communications? And he was very clear, it depended upon the relationship, patterns, behavior, and things like that, as to how right-wing extremists would interpret comments. So really his testimony was, President Trump said something, and right-wing extremists interpreted it in a certain way. And specifically when he said right-wing extremists, he referred to those figures. He also said that, so the characteristics of these communications are common with normal political speech. He talked about communication methods, what he called double speak, the front door, back door, and I'm sure you guys all feel comfortable that when we go for a job interview versus when we talk to our significant other, we are engaging in double speak, or maybe front stage, back stage. One of those methodologies. So he testified about that, but the important thing he said was that all of these forms of communication, all these methods of communication, call and response and things like that, are common in political discourse, are commonly used in political discourse. And the difference with far-right extremists is that they couple it with violence. That was sort of wasted. And of course, it was very clear that many of these people interpreted other Trump's comments. So that's how Professor Simi testified. So let's apply that to the law. Okay, and I will talk about a few things. So the James versus Beyond Media Inc. That's 300 F3rd 683, and that's in the Sixth Circuit. And in that case, the argument was that basically there was sort of an ongoing process of developing a method of communication, and that after a while, the person hearing the communications was conditioned to respond in a certain way. And the court very clear, it said, this glacial process of personality development is far in the temporal imminence that we require to satisfy the Brandenburg test. So you have to have the temporal imminence. So all of the stuff that Professor C talked about does not meet First Amendment standards. All prior conversations and years with eminent development. That has been explicitly rejected by the courts. It has to be imminent, okay? And it can't be communication that, whether even if it advocates, and none of these communications advocate, which I'll get to that, but it has to be imminent. And so Professor C's framework of this pattern of behavior, it may apply to how people receive those communications, but it doesn't constitute First Amendment standards, and we think those standards are very, very clear. The court also said that the mere tendency of speech to encourage unlawful acts is not a sufficient reason for banning accounts of social media, a direct connection between speech and imminent illegal conduct. So even if speech advocates something, even if it encourages it, the tendency to encourage it is itself not an absolute reason, absent of showing a direct connection between speech and imminent illegal conduct. So there has to be a direct connection. So President Trump saying, come on January 6th, will be wild. That is not a direct connection between speech and imminent illegal conduct. And that's a pretty straightforward case law. Now,
I'm sorry, that's still the...
James versus Beyond Media, and they have a number of citations in there. The Kinsight page 698. And they cite Ashcroft versus Free Speech Coalition and McCoy versus Stewart in the quotation block that I'm referring to. But it's a great case. I suggest it for everyone else. The second case, and I'm not going to be off the advance, I don't want to provide an entire legal brief here, but I'm going to talk about a couple things. Two more cases. Hess versus Indiana, I'm going to cite that's the U.S. Supreme Court case in 1973. And there has to be evidence or rational inference from the import of the language that the words were intended to produce and likely produce imminent disorder. Okay?
Mr. Kessler, would you just slow it down
Certainly,
a little bit?
I'm mindful of time. I guess that's what I'm talking
No,
about.
I'd rather you slow it down so I can actually absorb what you're reading versus
Let's
start again with Hess versus Indiana.
Hess versus that's 414 U.S. 105. Okay? And Hess says there has to be a couple things. There has to be intent. In other words have to be intended to produce. And they have to be likely to produce imminent disorder. And they could not be punished by the state, but rather they had a tendency to leave bonds. So you have to look at the import of the words, their direct meaning, not a particularized coded meaning. And in fact, Professor Simi never testified that President Trump intended. In fact, he disavowed any testimony of President Trump's intent. And Professor Simi was very clear that the words used, no matter who's using them, whether it's the term flight or something else, have an impact on the listener depending upon circumstances. It's all contextual. Here's the last case, and I think this case is really dispositive here. And the case is Ranguma versus Trump. Ranguma versus Trump. And that's spelled N-W-A-N-G-U-M-A versus Trump. And that's 903, that's 3rd, 604. And this is why this case is so dispositive. This was a rally involving President Trump, the same one who's here today. And he spoke at this rally. And this is described in the case. And President Trump spoke for about 35 minutes. And Ranguma, she attended the rally with the intention of peaceful protest. Okay? And her behavior precipitated directions from President Trump to the crowd on 5 different occasions during that speech. for her and a few of her colleagues to get him out of there. That's what he said, get him out of there. And you, the court, heard video of how President Trump delivers those comments. Types of comments, not just video. He said, get him out of there. And in response, what happened is the crowd, members of the audience assaulted, pushed, and shoved plaintiffs. And one of them was actually punched in the stomach. And the argument was that that this implicitly encouraged the use of violence. Now, President Trump said a few other things. He said once, after his fine, get him out of here. He said, but don't hurt him. Actually, the case doesn't say but. It says don't hurt him, is what President Trump said. Okay. And what the court did a couple things. The court said, even if we get him out of here, because if you did implicitly encouraging unwanted physical touching. So the court didn't accept it implicitly. Didn't rule it implicitly. It said, even accept it. The charge in Kentucky law in this case was inciting to riot. So it's incitement and riot, both of which we were lesser standards here, but certainly incitement. And the court said the notion that Trump's direction to remove a handful of disruptive protesters from among hundreds or thousands in attendance could be deemed to implicitly incite a riot is simply not plausible. Even in those circumstances. And this is, Your Honor, why I was very careful to submit a very specific hypothetical to Professor Seeley when I was asking him questions. I asked him, well, if President Trump would say 5 times, get him out of here. And this crowd, even if it were filled with right-wing extremists, and then later said it 5 times, as opposed to only 1 time, don't hurt. So I went to this exact hypothetical. And even Professor Seeley hedged a little bit and said, well, it still sort of depends on context. Okay? And so he wasn't quite willing to say, yes, that was an incitement to violence. But the court here is very clear. That is not an incitement here, it says incitement to riot. Okay? And the court focuses on the incitement part of that. Even there, the court was very clear, that is not incitement. And then the court especially went on and said, especially, for any implication of incitement to riot as violence is explicitly negated by the accompanying words, don't hurt. The words have meaning. The admonition, don't hurt, not be reasonably construed as a version to hurt. So what the court did there is the court, and I don't want to say the court rejected Dr. Seeley's thesis, because the court didn't say, well...
Did Dr. Seeley testify in this case?
No, I'm sorry, Professor Seeley, did I say doctor?
Well, he said doctor, and then I said doctor, and I'm sure he has a doctorate.
I don't believe he did. I don't believe he did. But what I'm saying is, Professor Seeley has said, well, the words again, you reasonably interpreted there. The court doesn't accept that framework for a First Amendment analysis, which is what controls here. So I'm not saying he's wrong. I mean, right-wing extremists, they very well may usually do that. But I'm saying from a constitutional objective standard, what the court does is the court looks at the objective words. Okay? The court went on, as part of this ruling, and said, the fact that audience members reacted by using force does not transform Trump's protected speech into unprotected speech. The reaction of listeners does not alter the otherwise protected nature of speech. So in other words, the courts and we look at the objective meaning, the plain language of terms. We do not look at how those terms may be interpreted by the audience. And they later said, in that same case, it is the words used by the speaker that must be at the focus of the incitement inquiry, not how they may be heard by a listener. So again, we look at the words itself. Okay. And then, and the case sort of cites a substantial amount of case law. I'm not going to cite all that, because I didn't want to keep this motion short. So we're not talking a difficult legal faith to understand the applicability of Longuma versus Trump. In fact, I submit that the petitioner or the plaintiffs in Longuma versus Trump used, I don't know exactly what happened, but I'm assuming very similar arguments to petitioners here, because they talked about the objective use of words. The court rejected how they're interpreted by listeners and the words themselves. In that case, get them out of there. Even that, the court was unwilling to accept as incitement. And the court was very explicit, saying that it was negated. And of course, we have other courts talking very much about the incitement, and we cited some of that in our motion, even particularly provocative, directed language, very foul language in the cases, directed at audiences, and even that far closer in time than what we had here, was treated as not imminent. So, under the imminence standard, absolutely nothing that President Trump said prior to January 6th would constitute incitement. And the most they've been able to come up with is the will be wild tweet. That's the most they've been able to come up with.
What about the lit speech?
I'm getting there. I'm fixing to get there. But I said prior to January 6th.
Oh, I'm sorry.
So what I'm saying is that's a pretty easy analysis. Under the imminence problem, none of that stuff happens. Which brings the petitioner's case to one item, which is the illicit speech. And absolutely nothing in there. Nothing in there. None of President Trump's words were all plans. And look, if the Longuma court says, big crowd, protesters in there, crowd angry, get them out of here, 5 times, direction to the crowd, focus on that person or those few plaintiffs, demanding that they be removed, get them out of there. If the court doesn't accept that as a call to riot, as incitement, there's no way that when President Trump says, we need you to fight for our country, We need to march around the Capitol. There's no way that is consent. And then, of course, the peaceful and patriotic. The petitioners seemingly developed an argument that, well, he didn't explicitly say, be peaceful and patriotic. President Trump really said, I know you'll go down there peacefully and patriotically. But he emphasized peacefully, and he emphasized patriotically in that speech. On the same
When you say
stage.
emphasize, you mean in what way?
But he made strong words. He talked about it vociferously, and it was toward the end of the speech, and ultimately, what we are here to do today. I am with you. I'm going to go down there with you, peacefully and patriotically. And, and so he created common sense of purpose as the, penultimate culmination of the speech. That's why it was towards the end. And so, that certainly negates as well any violent intent. So the words themselves, the objective meaning and objective use of words, there is no call to violence. And everything that Trump says, fight, is a common political metaphor, meaning a political fight. And Trump on multiple occasions says, we're going to go down there and we're going to give our representatives courage. And we're going to demand that Vice President Trump has to do the right thing. Obviously, I'm paraphrasing. I'm happy to repeat the speech. But you have in front of you, a transcript. And you can look at those words. And under the objective meaning of those words, none of them are consent. Then the last argument that they make is that President Trump failed to do enough to stop the riot once it started. Okay, so they have sort of three, within the world of speech, the evidence, they sort of have three components. First component is all stuff in advance of January 6th. It doesn't make any sense. Second component they have is the January 6th speech. And they say that's what incited. And even their own evidence, even according to the January 6th report, the January 6th report says the violence started well before President Trump finished his speech. So that part of the violence, he certainly didn't incite the January 6th speech. And then their argument is, well, he failed to stop the ongoing violence. And that's inaction, which has never been held to cause incitement. And even and it's not an overt voluntary act. There's no evidence of that. Even supporters require specific intent. And the only intent is President Trump's absence, what they call absence. I mean, we dispute that factually. There's tweets in there where he says, be peaceful, stay peaceful, and then a video, and 3 communications. And of course, they say that's not enough. And under the Brandenburg standards, well, it's not even close to enough. That's not incitement. So that's our motion for directed verdict, Your Honor. The court has not yet ruled on these First Amendment issues, and obviously we're asking the court to rule on it at so when I was about half-time motions. But it has to be pretty thoroughly briefed. And the reason I waited was to see what evidence. I mean, maybe they had evidence that Trump was on the phone with Prof and go. I mean, maybe they wanted to bring some evidence in there. He was sitting in a room and they were planning out, what people were going to say and do. But there's none of that. It's all speech. So even on the grounds of speech, what President Trump did that day is not something that very well established First Amendment principles.
Are you prepared to respond now, or do you need a few minutes to regroup? Or?
Your Honor, we're happy to start now, but I think, given the time, it might be better to give us a few minutes over lunch.
So this is where I am, is that prepared to rule after lunch. We did start 20 minutes late today, so I think Mr. Gessler spent about 15 minutes, so if you think you can respond at the same amount of time, we would just probably break at 12:30 to 1:30 for lunch.
That's fine, Your Honor. Thank you.
Okay.
As we just heard from Professor Magliocca, to have engaged in insurrection means any voluntary act by word or deed in furtherance of the common unlawful purpose of the insurrection. The 14th Amendment is not limited to incitement. It includes any voluntary conduct, including specific acts of encouragement that further that common end. President Trump was not just a part of the insurrection on January 6th, he was the leader of the insurrection. He summoned the mob with repeated tweets identifying January 6th as a time to descend on the Capitol. We've seen from both the written evidence and the testimony of Professor Sini the effect that Trump's statements and tweets in advance of January 6th had on mobilizing violent extremists to come to the Capitol ready to fight. And he did that using violent language. Just hours after he tweeted, "Come to DC, will be wild," he retweets from a right-wing extremist website a video chanting "Fight for Trump" over the course of over a minute, just to be sure that his supporters would have no doubt what his intentions were. Second, his lies gave the mob their common purpose. Beginning well before the election and leading up to it, he repeated claims that the only way he could lose the election was if it was stolen, and immediately on election night, he began repeating those same claims, even after court rejected his lies, and even after advisor told him there was no basis for those claims of fraud. He created a false and desperate expectation in his supporters that the only way, by January 6th, they could overturn the results of what they thought was a stolen election was through force and violence. Third, he incited the mob with his speech. at the ellipse. And President Trump repeatedly wants to suggest that his speech was all about being peaceful and patriotic. But here's what we know. We've introduced findings from the January 6th report showing that President Trump had been briefed well in advance of his speech on the ellipse on the fact that tens of thousands of his supporters refused to go through the manometers because they were armed. Despite knowing that, Trump used violent language referring to fight or some version of that 20 times. He told his supporters they get to go by a very different set of rules because fraud was involved. That is an implicit call to violence that, based on a long-standing pattern of call and response that he developed among his supporters, he knew and his supporters knew were intended as a command to go beyond the normal rules of political engagement. He told them, do not take back our country with weakness, and he repeatedly painted a target on the backs of Vice President Pence and members of Congress. And he told them all, not only that they should go to the Capitol, commanding them to go, but told them he would be right there with them because he knew that telling them that would encourage them to go to the Capitol prepared for violence. That's classic incitement. The cases that President Trump cites are fundamentally distinguishable. The November case was a case where Trump simply said, get him out of here, with no violent rhetoric. The plaintiffs in that case identified no other context that suggested that his words would likely be taken as a command to violence at the time. That is not what we have here. We have months of context showing what Trump was telling his supporters to do on January 6th and why they were supposed to be there. And nobody in that case said, fight like hell, and fight, fight, fight. It was a fundamentally different situation. Fourth, Trump incited the mob during the attack with his 2/24 tweet against Mike Pence. This was an hour after he learned that the Capitol was under violent attack and members of Congress and Vice President's lives were in danger. And he told them, Mike Pence didn't have the courage to do what needs to be done. USA demands the truth. In context, USA demands the truth means the mob that is pounding the doors of the Capitol demand the truth. They're not going to stand for certification. They're going to stop it. At the very least, a reasonable fact finder could draw these inferences about what Trump intended in issuing that tweet. And fifth, Trump refused to summon a federal law enforcement response to stop the mob or to call the mob off until it was clear they were not going to be successful in disrupting the certification. The evidence we introduced, including findings from the January 6th committee, made it clear. It was that after 4 o'clock, it was clear that the certification was not going to be disrupted. Members of Congress had reached safety. Reinforcements had arrived through no effort of President Trump's, and the insurrection was starting to wind down. And it was at that point only, after 3 hours of watching TV, that President Trump finally told his supporters to go home. Now, President Trump's defense that this is just inaction, this is action. It's a very well-established principle of law that inaction can support the finding of wrongful conduct when there is an affirmative duty to act. When does an affirmative duty to act arise? Well, one, there's a legal duty to act. President Trump swore an oath, the most powerful oath anywhere in the Constitution, to preserve, protect, and defend the Constitution. That is a legal duty to act. He also had a legal duty to act when you set the events in motion. And certainly we've seen that Trump did that here. And we're prepared to provide additional authority in our proposed findings of that and conclusions of law, demonstrating that these are the kinds of circumstances where there is a duty to act. But what else does his inaction show? It shows that he intended the results of the insurrection, that he intended that the insurrection achieve its ends, because when everybody is telling you you have to do something and you're the most powerful person in the world and you do nothing, that tells us you want them to succeed. I'm pulling up Plaintiff's Exhibit 78, some of the findings from the January 6th committee. And if we go to page 150, page 46, finding 150, which the court has previously said was admissible. Evidence from the committee's investigation showed that the president, when told that the crowd was chanting "Hang Mike Pence," responded that perhaps Vice President Pence deserved to be hanged. And President Trump rebuffed pleas from Leader McCarthy to ask that his supporters leave the Capitol, stating, well, Kevin, I guess these people are more upset about the election than you are. What clearer evidence of specific intent to incite and aid an insurrection could you ask for? President Trump's defense is that the First Amendment protects his conduct here. But we've seen that his conduct was not just incitement. His conduct was speech adjacent to criminal conduct, mobilization, organization. We've also seen that his conduct falls within the words of the 14th Amendment. And so Trump's argument appears to be that the First Amendment displaces the 14th Amendment, but there's no legal authority for that at all. And as we laid out in the opposition to President Trump's anti-SLAPP motion, that simply cannot be right. The 14th Amendment does not impose any criminal penalty. It simply provides an additional qualification for office. And there's nothing unconstitutional about enforcing that qualification, even if the insurrection activity comes by word. But in any event, the standard for incitement is clearly met here. Number one, President Trump advocated explicitly or implicitly unlawful violent action. We've seen that he called for the crowd to fight like hell, to go by a very different set of rules. We've also heard evidence providing context for what those words meant to Trump and to his supporters through a long-standing pattern of call and response in which he could speak in coded language because his supporters would understand exactly what his coded language meant. That was the testimony you heard from Professor Sweeney, and I would direct the court's attention to the Seventh Circuit case in United States versus White, 610 F. 3rd 957, in which the court said that threats or incitement need not be in explicit terms. They can be also in coded language that is intended and understood as a command to violence. And that's exactly what we saw with President Trump's speech on the lips, and that's exactly what we saw in his tweet on 2/24. And of course, the second prong of the incitement standard is that the speech was likely to incite imminent lawless action, and of course that's true here. Of course, you have a crowd of tens of thousands of people, half of whom refused to go through the magnetometers because they were armed or carrying prohibited items. Those are the findings in the January 6th report that we introduced. This is like summoning a mob out front of someone's house where everyone has pitchforks and torches. And you don't say, go burn down the house, but you give a speech that makes it pretty clear to everybody exactly what you're telling them to do. That's classic incitement. So then Trump's last defense is, he didn't intend it. He incited insurrection accidentally. But of course, intent can be inferred from circumstances and from conduct. And the court doesn't have to check their common sense at the door when determining what Trump intended by his words and his deeds. And you have to look at the whole context and not just take one word of the speech out of context. We heard Professor Sweeney testify about Trump's long-standing pattern of encouraging and praising political violence and cultivating a relationship with violent extremists. There's a reason we haven't seen political violence of this magnitude in the U.S. in response to speeches by President Obama or President George Bush or Nancy Pelosi or Mitch McConnell. Other leaders don't talk this way, and they don't keep talking this way when they see how their violent supporters respond to the words they utter. Now, we saw Trump retweeting the warning by a Georgia election official, Gabriel Sterling, about how someone was going to get killed as a result of his violent rhetoric and his refusal to call on his supporters. And we saw that his response to that explicit warning was to double down, and that's not the action of someone who's concerned about violence. How else do we know what Trump intended? He thought Vice President Pence deserved it, finding 150 that we previously looked at. We also saw his tweets after the attack on January 6th. These are the things that happen when an election is unceremoniously ripped from his victims. He was praising the violence, remember this day forever, because he was in league with the insurrectionists. And we saw what he was saying in years later, that fraud allows suspending all rules, including the Constitution of the United States. That was his mental state on January 6th, and that was his mental state even years later. He has violated his oath. He engaged in insurrection. Thank you.
Do you want any more argument from me, Your Honor? I'm not insulted when you say no.
I think we should, you want to say something? Well, Mr. Clark, you said so little. Unlike some other folks that I'm going to give you a chance.
Your Honor, it's just nice to say something other than my name in the question. Just very briefly, Your Honor. Rule 50 is inconsistent with a 113 action. The idea behind 113 is we get an expedited resolution of this process. We get it all bundled up, and it goes out on appeal for the Supreme Court to consider whether they want to hear it or not. I think if you consider how this could play out, if the court were to entertain Rule 50, is if the court were to grant Rule 50, we could end up in the Supreme Court on a 3-day expedited appeal. The Supreme Court would say, actually, after a lot of briefing and all that, say, actually, you know what, we think the district court erred, did not grant Rule 50, let's slow that down. We then have a whole half of this case, we would still have to try. And all of a sudden, January 5th is looking really close when the Secretary is going to have to make a certification decision. I point to Rule 81 of the Colorado Rules of Procedure, which say that when a special statutory proceeding, which 113 undoubtedly is, provides its own procedures, and the rules of civil procedure are inconsistent with the special statutory proceeding, the court should follow the procedures of the special statutory proceeding and not those of the rules of civil procedure. Rule 50 talks about a directed verdict. There's not a verdict at the end of 113 action, Your Honor. There's an order directing substantial compliance with the election code. So we just think that this Rule 50 motion is procedural and probably should be denied. Thank you.
Okay, so we're going to take it under advisement and hopefully have something to say in response when we reconvene at 1:30 today. Okay, Mr. Kessler, you'll be prepared with the first witness?
Yes, Your Honor. Last housekeeping thing for tomorrow, we have a witness who needs to start at 1 o'clock, so if you can just do that planning process, I want to begin that long advance.
You've done that 3 times already today.
That's a notice to pay particular attention to what I'm saying.
Okay, we will, why don't we just make it 1:30 and we'll be back.